Your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning, Your Honor.
Good morning and welcome to today's sitting of the Appeals Court. I'll begin by introducing the panel to you. To my right is Justice Gregory Massing. To my left is Justice Jennifer Allen. My name's Ariane Vuono. We have 7 cases on the list today, so we're going to get started immediately. I want to remind everybody that they have 15 minutes to present their argument. We have reviewed everything that you have submitted, so you can get right to your most salient points as soon as you can. There is no rebuttal in the Appeals Court. I think that takes care of everything. So the first case is going to be Commonwealth versus Stephen Fairburn, 2024-0955. Good morning.
Good morning, Your Honors. May it please the Court, my name is Daniel DiMaria. During Officer Pucci's direct, the jury heard the complainant was very upset, screaming that someone was trying to murder her. The defense immediately objected, and the judge gave a curative instruction but denied the motion for a mistrial. This statement is categorically different from the complainant's testimony that she feared she wouldn't get out. And one expresses fear of confinement. The officer's statement imputes an intent to kill. And I would argue the judge erred in failing to grant a mistrial and that asking jurors to disregard the someone was trying to murder her statement is tantamount to asking them to ignore an elephant in the jury box.
Can I ask you a question about how this came up? Was there any discussion of this, a pretrial, a motion in limine, anything?
Not that I'm aware of, Your Honor.
It comes up and the judge goes, are you admitting it for a excited utterance or something like that? And the ADA says no, and then the judge says, control your witness, as if there had been some prior discussion of it.
Not that I'm aware of, Your Honor. And the prosecutor admitted that he tried to lead the witness away from that. But there was no motion in limine on that issue, so far as I'm aware.
And so the implication that the prosecutor was somehow was doing something wrong is sort of unfair, right? I mean, there's nothing. It's the witness blurting it out, not the prosecutor
Exactly, Your Honor, but that does not cure the effect, even if it was inadvertent, even though if the Commonwealth, had nothing to do with it. The question is whether the jury could have realistically been expected to follow a curative instruction. I argue they could not have. I do suppose, Your Honor, the prosecutor could have told the witness before his testimony, in private, do not mention this, it's not admissible. So he didn't do anything wrong per se, but the prosecutor could potentially have avoided it, but we look at the effect, not whose fault it was.
And why isn't it admissible? It's she comes to the scene of the crime, she goes, somebody's trying to murder me! That sounds like a spontaneous utterance.
Then she would have had to testify to it, not the officer. The officer did not hear it directly. I believe the officer heard it from one of the other witnesses, if I'm not mistaken.
Well, she wouldn't have to have testified to it. It's an exception to the hearsay rule. So whoever heard it could have testified to it.
I suppose so, Your Honor, but the trial court did take the position it was not admissible. And I would say it was highly prejudicial, even if it was an excited utterance. If prejudice outweighs probativeness, it would not be admissible.
You were indicating that that the statement itself seems to have presented some sort of different angle or a different information that the jury was given at that time. Can you specify that a little bit? Because it seems to me that the jury was well aware of the fact that this particular person was semi-hysterical and had been injured. And so I don't know how shocking or surprising it would have been that she had made comments about her situation to neighbors and police officers, etc.
I mean, I would say during her own testimony, she was testifying that she didn't think she would get out. And to me, that's a lot more tame, a lot less inflammatory than someone is trying to murder me. I don't know if that answers Your Honor's question, but it just took it up to another level. And I will say, in Picard versus Commonwealth, where the court did hold a mistrial, was necessary. The prejudicial statement was whether or not the estate had filed suit against the defendant, and I would argue that's a lot less prejudicial, and even under those circumstances, the Supreme Judicial Court held that it was so prejudicial that a mistrial was properly granted. And again, Your Honor, Picard versus Commonwealth, 400 Mass 115. My second point, Your Honors, is that the intent instruction collapsed intent into mere touching, and as the court will recall, the judge instructed first that the defendant intended to touch the person of the complainant, second, that the defendant intended to touch the complainant, and then he stated to prove the first element, the Commonwealth must prove the defendant touched her. And I would argue that framing equates actus reus with mens rea. And intent in this case was a very, very deeply contested element. The appellant testified any contact between he and the complainant was accidental during a scramble where he was awakened, blankets ripped off, both on the floor. And so telling the jurors that proving a touch proves the first element reduces the burden of proof.
So you would agree with us that, though, that we have to look at the jury instructions as a whole in assessing, correct?
I do agree, Your Honor.
Because it seemed to me that the error, if we were going to call it that, was at the very beginning when they were sort of outlining, when he was beginning to sort of outline, but then when he went into depth as to what each piece was, that the instruction was correct. Do you agree with that?
I do agree with that, Your Honor. The rest of the instructions were correct, but the judge never disavowed the erroneous information. Jurors basically heard two versions, and without a correction, they could have defaulted to the simpler one, which was wrong, that touching automatically equals intent. And it probably was, I'm sure it was a slip of the tongue on the judge's part, but it was a slip with consequences.
Not so consequential that there was an objection.
I would argue that it could be ineffective assistance of counsel, but we don't even need to get there because it was such a substantial risk. But in either event, counsel absolutely should have objected, given that the burden was lowered due to the jury instructions as given. And then my third point, Your Honors, the court charged that a person cannot lawfully act in self-defense unless he's attacked or immediately about to be attacked. As the court knows, Massachusetts law does not require an actual attack for a self-defense claim. Imminent harm is enough. And the jury instructions were slightly different. They are at page 26 of the Commonwealth's brief. Footnote 5 has the model instruction, whereas the top of the page has the instruction given. Again, that's page 26 of the Commonwealth's brief. And I would argue that the court's instructions basically front-loaded this idea that a person must be attacked, which could have misled the jury. And
Well, I mean, immediately about to be attacked isn't quite the same as must be attacked, right? I mean, doesn't the immediately about to be attacked sort of carry that imminent threat piece?
But under the law, you don't need an attack or an immediate attack even.
Well, about to be attacked. It didn't say it. It's about to be attacked.
I would still argue, Your Honor, that the instruction was misleading. And even if it did follow, and you'll see that it's a bit different than the model instruction, it front loads it more. But I would argue that there is case law from the Supreme Judicial Court. It's not in my brief, but Commonwealth versus Cruz, 456, Mass 741. Commonwealth versus Kelly, 470, Mass 682.
Well, you're going a little bit too fast if you want us to get those down.
Oh, I apologize, Your Honor.
It's okay. Just could you repeat those citations, please?
Commonwealth versus Cruz, 456, Mass 741.
Okay.
and Commonwealth versus Kelly 470 Mass 682.
Thank you.
And they both say that we're not bound by the model instructions. They're simply guidance. They can be wrong. And so I would argue that the instruction really should clarify that an actual attack is not necessary. And this is a very interesting case in that the jury acquitted him of strangulation. And I know my sister in her supplemental appendix put photographs, and you can see marks around her neck and whatnot. But clearly the jury grappled with this, and so I would submit that the erroneous self-defense instruction and the intent
Wasn't your client testified, right? And didn't he testify that he was attacked?
He described that he was sleeping and that she came in, pulled the blankets off him, he fell on the floor, and a scramble ensued.
A tussle.
Okay.
And I may not have heard your question, Your Honor. Did that address it?
Yeah, I think so.
Okay. And so I would argue that, again, Glass says we don't need an actual attack, and that for the three reasons I cited, Mr. Fairburn is entitled to a new trial. The murder accusation inflamed the jury. The intent instruction lowered the burden. The self-defense charge misframed the threshold. And so in a case where the Commonwealth already lost on strangulation, I would argue the court should vacate count 2 and remand. If the court were to find, as I would argue it did, that the murder statement tainted the whole trial, it should order a new trial on both counts 2 and 3. And if there are no questions, I would rest on my brief.
1 second. None. Thank you very much. Counselor?
Good morning. May it please the court. Assistant District Attorney Megan Monahan on behalf of the Commonwealth. First, I'd like to just thank the court for rescheduling this argument and accommodating last week's issues that arose, and I appreciate the clerk's office.
No problem at all. We're
working.
glad everybody's healthy and feeling better. That's all that matters. Okay.
Thank you very much. Your Honor, I'll direct first to issue 1, particularly that the trial judge's curative instruction was more than sufficient to cure any possible prejudice by Officer Pucci's testimony, which was one-off comment, it was limited, and it was cumulative of other testimony, and where this was a case of a very prolonged, volatile attack, the statement that she thought that he was going to murder her was not prejudicial, and the curative instruction told the jury not to consider it. Jurors are presumed to follow those instructions. Your Honor, significantly, the defendant's brief does not cite any case law that would say that a mistrial was necessary in this circumstance. The case that the counsel cited in oral argument, Picard v. Commonwealth, 400 Mass 115, that actually was the trial judge's ruling. The trial judge ordered a mistrial, and the SJC made a note that a curative instruction would have been sufficient in those circumstances. So it's significant here that there's no case law directing that a mistrial was necessary or appropriate under these circumstances.
Would it ever be an abuse of discretion to deny a mistrial for, in a situation like this? Or is there any sort of statement that could come out that would be so prejudicial that it really couldn't be ignored?
Not under the cases or the circumstances I have seen. I would think, Your Honor, that we get into mistrial territory where it is repeated or flagrant disregard for a court's ruling, and it continues to come up at trial. So again, this was not repeated, this was not referenced by anyone, and so I would suggest that a one-off comment, it is entirely within the judge's discretion to offer a curative instruction. As for the second issue, Your Honor, there was no substantial risk of a miscarriage of justice when the trial judge briefly misspoke and inadvertently, at the beginning of the instructions, repeated an element. As the court has seen through the instructions, the thorough and substantive resuscitation of the instructions, the elements were correctly stated, and I would suggest that where there was no objection on the record, either by the prosecutor or defense counsel, it was really taken as a slip of the tongue or even so quickly rectified by the thorough instructions that this was not an issue that caused prejudice, let alone a substantial risk of a miscarriage of justice. And I would also suggest, Your Honor, that in evaluating substantial risk, lack of intent to touch was not a contested issue at the trial. The defense was self-defense. And so even the defendant testified, he grabbed her shirt, it ripped. He acknowledged that he may have hit the victim's head against the floor. So the defendant's testimony and the closing argument in and of itself was self-defense. There was no allegation or no argument of an accidental touching or a negligent touching such that there really was no prejudice where this was not a contested issue at trial. Whether it's been labeled that at appeal is a different story, but at trial, closing argument and the defendant's testimony were squarely on self-defense.
Did the defense have to do with, I was defending myself from an actual attack, or I was preemptively defending myself from a possible attack?
Your Honor, if in instructions requested by the defendant, we look at the.
I want to know about the facts. Like, was the facts and the closing argument? Was it I was attacked and I was defending myself, or I was about to be attacked, so I defended myself?
I read both the testimony and the closing argument that the defendant was attacked and responded, grabbing the blankets such that he fell out of the bed. The victim kicked him. That was the testimony. The victim first kicked him. Then he grabbed her shirt. So that kick, whether it's the grabbing of the comforter, which I could argue would be the beginning of the attack, the kick itself is also could be the beginning of the attack. No matter what, there was, at least the defendant's allegation was there was an attack. It was not about to be attacked, which goes into our third issue again. The instructions did track the model instructions, and the closing argument and the self-defense was about being attacked. So again, there would be no substantial risk even if this court were to find any error in either instructions. If there are no further questions, the Commonwealth would rest on its brief.
No further questions. Thank you both very much.
Thank you very much.
Okay, that case is under advisement. The next case will be Commonwealth versus Joshua LOFINK, 2024-0194.
Good morning, Your Honors.
Morning.
In this case, the central case certainly is whether a lesser included offense should have been given an instruction for mayhem, assault and battery by means of a dangerous weapon.
Can I reframe that question a little bit? Maybe the question should be, does it matter?
It does matter.
Okay.
It matters because the jury could have found the evidence insufficient or sufficient to find a doubt or a reasonable doubt that he committed mayhem and that he could have committed assault and battery by means of a dangerous weapon, SBI.
Well, as they were instructed, if the jury found that he did not have the intent to maim, then they would have acquitted, as instructed, on the mayhem.
But that choice should have still been presented, and that's what lesser included offense instructions are for. And Commonwealth versus Woodridge makes that clear, and that's a very expansive interpretation by the Supreme Judicial Court that lesser included offenses are important in the jurisprudence of the Commonwealth of Massachusetts for that reason. That way they won't be, a person might be acquitted or a person might be found guilty, not of the right charge that was proven beyond a reasonable doubt. The jury might have said assault and battery by means of a dangerous weapon, and under the facts of the case, that would have been the proper conviction, not the conviction here. I'm simply asking that.
I still don't see why, as Justice Massing is pointing out, why the jury simply could not have, if they were so inclined, acquitted your client of the mayhem charge and then convicted him of the second charge. It was all based on the same chain of events. There wasn't two separate events, two victims, of course, right? But it was the same chain of events. So I'm still having a hard time understanding why an extra instruction would have aided you. And so, of course, when you talk about the law and lesser included, how important they are, it's true to a certain extent, but not always, because, of course, in this case, the lawyer didn't ask for the lesser included, and there was more of a different strategy that maybe a lesser included would not have been so helpful. But anyway, back to the first question. I still don't understand why the jury was in any way misled about what they could or could not do in terms of the facts of the case.
Well, because they were not so instructed. They did not have that choice in front of them.
But if the jurors were thinking, look, I think this guy just ain't bad, but I don't think it's as bad as mayhem. And if it wasn't, they had this. Let's find. But I don't want to let him get away with something. But I want to let him get away with something less. So they did find him guilty of the assault and battery on the other charges. I mean, so they did have the option to essentially to choose between a lesser offense and a greater offense, and they chose both.
Well, the choice is really, I don't see that as a real choice. The way that the Commonwealth chose to indict the person for the lesser included offense as well. So I don't think that's a choice. And I think throughout how the case was tried, it was never tried as a lesser included offense, assault and battery. Now, on legal research and reflection, they are, but you have to analyze the indictment's language, the case law, to come to that.
Actually, defense counsel knew it was a lesser included offense. He put it in one of his motions.
Well, in terms of assault and battery by means of a dangerous weapon, serious bodily injury, I must say I didn't see that being sufficiently raised. Now, assault and battery by means of a dangerous weapon, I think there was an issue of that, whether that was included as a lesser included offense in terms of the ABDW.
There's cases that the Commonwealth cites, like Mills, that says that that the judge shouldn't take away counsel's ability to do an all or nothing strategy. And where it seems that counsel knew that you wrote in a motion that this is a lesser included offense and knew to ask for a lesser included offense on the other charge. Why isn't this actually an intentional?
Well, his defense was intent. It was, and he specifically said in his open specific intent. ABDW SBI is not a specific intent crime. So I think he was more worried about the mayhem charge, as he well should be, given the facts and the nature of the charges. But he asked for, in his opening, specific intent, and he just didn't follow up by asking for the lesser included offense instruction. Now, the defendant probably, in all likelihood, was going to be convicted of ABW SBI. Okay. I've included, there's abundant evidence as to that. In fact, it's actually recorded, the assault and battery.
Right.
It's actually recorded.
We've reviewed the exhibits.
I'm sorry,
We have reviewed the exhibits. They were.
Okay, well, I've tried very hard to bring that to the court's attention. And there's case law on my side that indicates that a lesser included offense should be given there if it really results in substantial benefit to the defendant. It's not a hair length bit of difference case. There's a big difference between mayhem, a heinous crime as described, and we'll just call it A and B at this point. The lesser charge, both in terms of sentencing and scope of criminal liability. And I think that in this case, I don't know why that wasn't given. I think,
But you would agree that would be a tactical decision on the part of defense counsel, in consultation with the defendant, to not ask for the lesser included.
Well, if that happened, but
and that's happened time and time and again in many cases we've had, right?
Well, as a tactical decision, but there's no basis for that it was a tactical decision. I think it was simply a mistake that it wasn't asked for.
Okay, so now how can we be persuaded by that on the record that we have before us right now?
because the defendant was already charged with the lesser included offense in terms of separate indictments. And he would have been, there was no benefit for him. The only benefit to him was to try to reduce the mayhem charge.
Right, try and convince the jury I had no intent. I mean, I struck the person, the argument was volatile, I was being accused, I was worried about my girlfriend, the car was up on the sidewalk, et cetera, et cetera. Of course, you know the facts. And, but I never intended to maim somebody. That was not my intent. That's not a bad defense.
Well, I would submit that that was his best defense.
Yeah.
And that's why the jury should have been instructed. If he had no specific intent to maim Ferry and Hassan, then he could have been convicted for the lesser included offense. And the lesser included offense, which were separately indicted, would be dismissed, and he would be simply, no, the lesser, if the lesser included offense, he'd be found guilty of those. And
right.
he would receive a lesser sentence. So, I mean, there was a benefit, there was a direct benefit for him to request that instruction. And there is a case. I would simply say that the tenor of the law in the Commonwealth of Massachusetts that lesser included offenses should be given. And I think it was simply a mistake. Where I remember the lesser included offenses instruction was considered for assault and battery, the longer form. And there was no basis for that lesser included offense instruction because there was no doubt there was a serious bodily injury. In this case, there was, because there was plenty acting on the defendant's mind. And I think that this case presents a difference between a cold record case and a case where you're allowed to see the evidence, including the entire transaction. The victims were the aggressors in this case. From the time the defendant left his house with his girlfriend, they harassed him. And that's recorded, live and in color. There's no dispute about that. I don't see how it can be reasonably disputed. He peacefully walked down the street with his dog. And they passed by him, catcalling him or yelling at him or heckling him. And they actually pulled in front of him, blocking his path when they went into the entrance of the liquor store. Across double yellow lines, which is a highway at this point. So completely reckless behavior, confrontational behavior. I don't think it amounted to an assault by means of a dangerous weapon. I don't think it was close enough. But it's very aggressive behavior acting on the defendant's psyche, especially with his girlfriend whom he was walking with. Now, and you can see also by that Ferry in particular was irate.
So continue. This is your argument to the jury. So how does it end?
Well, it ends.
What are you asking me to do?
It ends when LOFINK, there's a fight and LOFINK stabs Ferry. Okay, that fight ends and Ferry runs up the street, slashes the tires, and then he's like at the end of the street. Hassan drives his car in the wrong way on a highway in the breakdown lane, and he says that he jumped the curb. And I put in.
I'm sorry. You've spent a lot of time now sort of blaming the victims.
I do.
So what point does that add to of your?
The point is that is exactly why intent was at issue, and that's why a specific intent was at issue, as the defense attorney said. It's grounded in the facts. It's not abstract. This is a fact-driven case. Perhaps they all are, but in this case, there's a clear record of exactly what happened. So the jury should have been able to make a choice and say, was this really a mayhem case with the specific intent to maim, or was this a person who overreacted and clearly committed a serious crime, as the jury found?
And then we're sort of back to the original question that was asked of you, I think by you, that the jury did that. The jury said, did he intend to maim or not? And if they thought that he did not, they would have acquitted him of mayhem, and they would have only convicted him of the other 2 counts. And you seem to think that if they had 6 choices, there would have been a different result.
Well, they had at least 4.
You want 2 more, you want 2 additional ones, 2 additional lesser included.
For each one, I want a lesser included offense for.
But the question for them would have been the same. Even if they had the lesser included, it still would have been the same question. Was there evidence beyond a reasonable doubt of a specific intent to maim? That was the critical question before the jury.
Well, I think under the Lattimore standard, the court can find that, unless they're included in offense instructions. I would respectfully submit that that's not the question. It's what is the verdict that's more consonant with justice, and that's why you have them. You could say that unless they're included offense instructions, you really don't need them at all, because if you meet the Lattimore standard, then it's just guilty as charged. You're supposed to give, a real choice, and in this case, the intent was a real choice. And this case is unusual because, admittedly, I don't want to blame the victims too much, but we see a course of conduct here, and it can't be ignored. I'm not ignoring my client's conduct, but they were the aggressors, and I just point out.
And the jury knew that. That was all apparent to the jury. All those facts were established at trial.
Well, I think there was.
I'm just saying in terms of your return to the facts of the case as you have been. That was the jury was well aware of how the altercation began.
Yes, and I use that in there, but I mean the culmination, the result wasn't met because there wasn't a lesser included offense instruction. You're supposed to use all those facts before you, and that's not the jury's fault. It's not the jury's fault that they and I'm not imputing any error on their error. But they should have, either it's the judge's fault or the trial attorney's fault. And the trial attorney's fault should have asked for that instruction. I'm simply asking for the mayhem charge.
I think Justice Massing has a question for you.
So the Commonwealth does agree with you that there's duplicative convictions here, and that the ABDWSBI should be vacated.
If the mayhem charge is
Right.
affirmed.
So, and they say, so assuming, we haven't decided the case yet, but assuming that if we were to affirm the mayhem and vacate the ABDWSBI, does it need to be remanded for resentencing?
Yes, I believe that it does, because I think that the case was tried, not on lesser included offense instruction basis, even from a practical point of view. They were treated as separate crimes. So if those crimes are no longer there, the defendant should be able to make his plea to the trial judge, whoever is available, that he should receive a lesser sentence. So I'm asking for him for a resentencing hearing if those charges are reversed.
All right.
If I could just touch on my last point, Your Honor.
Yep, you have 45 seconds. Please go.
Yes, there was no element of intent stated in the defendant's crime, a specific intent crime of malicious destruction of property. I would suggest that's necessary. It's not a crime. Without those words, it's not a crime. It's a civil tort. And there's no crime called vandalism. I mean, they can put that as a caption. I mean, it's not in the text, and the text is ambiguous, even what he was charged with, or of the law, wanton destruction or malicious destruction of property.
Okay. All right. No further questions? No further questions. Thank you very much for your argument. We had a lot of questions for you, and thank you for answering them.
Thank you.
Good morning, Your Honors. May it please the Court. Attorney Sarah Swan for the Commonwealth. The Commonwealth would agree that the lack of the lesser included offense instruction does not matter in this case. It's effectively an argument without substance here because, as the Court has pointed out already, the outcome would not have been different had the lesser included instruction been given. The jury had the issue in front of them. They had the 4 counts to debate and could have chosen the ABDW SBI instead of mayhem and didn't.
Why wasn't the case just tried on 2 mayhem charges with the possibility of a lesser included offense? Wouldn't that have been a lot simpler?
I wasn't present at the time, so I don't know the actual reason, but likely, yes, that might have simplified things. It might have just been a little more clear had that been done that way.
Kind of surprising. The judge didn't bring it up. The prosecutor didn't bring it up. Nobody brought that up at the time of the trial.
I went through that transcript in great detail, and it really never came. It did not come up to that degree where the question arose: how to line things up that way. I know.
Okay.
Yes. Nevertheless, though, The fact is, it was not an error for the judge to have not provided that instruction because the defense counsel proceeded on an all-or-nothing defense. Defense counsel just agreed that that was the defendant's approach, and in fact said it was his best defense.
Is it really an all-or-nothing defense when the defense is just one element? I mean, isn't an all-or-nothing defense like an alibi or a self-defense or something like that?
Well, I think with this particular charge, if you don't have that specific intent to maim, you cannot satisfy. The Commonwealth could not meet its burden. So without it, it's nothing. And so it would satisfy that all-or-nothing strategy here, and it did. So in the case of in proceeding in that with that strategy, it was his best defense, and because the case was so strong, this was the evidence was overwhelming here. There was testimony from the victims, from witnesses, from medical personnel, and video of what happened. So given the strength of the Commonwealth's case, this was defense counsel's best avenue to at least have the potential to mitigate, to go down from the mayhem to the ABDW SBI. The Commonwealth would also argue there was, so therefore it was not a mistake by counsel. This wasn't ineffective. It was certainly not manifestly unreasonable at the time. It was in fact effective. Further, it was not an error by the judge. And then without an error, without ineffective assistance, we can't get to a substantial risk of a miscarriage of justice. But if the court reached that, there is no risk of a miscarriage of justice when the jury had both counts to debate at that point.
Okay.
I would also point out that there is no question around the sufficiency of the evidence in this case. That's made clear in the appellate brief by the defendant that, in fact, it stated that the evidence was warranted conviction on those counts. And then moving on to the duplicative convictions, in this case, the Commonwealth does concede with the presentation given to the jury and with the facts of this case that should the mayhem convictions be affirmed, which we would argue they should, we would concede that the other two counts, 3 and 4, should be vacated, and the sentence is vacated and the indictments dismissed accordingly. However, it should not be remanded for resentencing because the sentences on those counts did not impact the overall sentence by the judge. The judge only sentenced on count 1, the first count of mayhem, and the remaining sentences were concurrent.
But why wouldn't that have affected what the judge might have thought would have been the appropriate sentence overall? In other words, they weren't the same sentence, of course, obviously, right? In the second, on the counts in which you now concede should be dismissed, it was 10 to 15 years instead of the 13 to 18 years, concurrent, right? So judge is always going to think that you never know what could happen with the case as when it goes up on appeal. How can we be assured that there would have been no other factors that the judge would have considered here?
Well, I think here, because there was no, I think the opportunity was there at the time to sentence differently, and the judge determined that the first count, that was sufficient, and really there could have been the option to sentence more harshly, and that did not happen. There was just the one count, and the rest remained concurrent as opposed to consecutive, as opposed to consecutive. So I think we can infer that.
Okay.
Finally, with respect to what is a vandalism charge, which there is a statute for, the indictment was not defective. It was clearly stated in the caption what the charge was. It was also, a brief summary of the events was also included in the indictment, which is all that is required.
Mr. Hickson cites the Cooper case. It's an old case, 1924, that the criminal complaint that omitted the element of the mental state was not sufficient. How do you distinguish, you don't address it in your brief, how do you distinguish Cooper?
In the Commonwealth's brief, we do say that a mens rea element is not required
But Cooper says it is.
from 1924.
Yeah.
Yeah.
So
There are more
we-
recent cases that clearly state that it is, the theory of culpability or every element is not required. I believe, I could find that in the Commonwealth's brief, those more recent cases, if you'd like. Which I can do.
So the answer is that you think Cooper's been implicitly overruled?
Yes, that would be my answer. Thank you, Your Honor.
Okay.
So in sum, the issues here, the Commonwealth believes are straightforward and the outcome clear, where the mayhem conviction should be affirmed and the vandalism count as well, and then counts 3 and 4 vacated. And if there are no further questions, the Commonwealth would rest on its brief.
All right, I'll just check with the panel for one moment. Not here, not here. Thank you both very much for your arguments. We appreciate it.
Thank you.
Case is taken under advisement. Our next case is Commonwealth versus Robert Iverson, 2024-1152.
Good morning, Your Honors. May it please the Court. My name is Robert DeOria, and I represent the defendant appellant, Robert Iverson. Your Honors, this is an appeal from an order of forfeiture by the Middlesex Superior Court following the defendant guilty plea to numerous firearms violations. The court ordered the forfeiture pursuant to General Laws, Chapter 276, Section 3, and since the court entered its ruling, the case of Commonwealth versus James came down. And that case wasn't in existence at the time of this forfeiture hearing. It came down months after the ruling. And under James, the Supreme Judicial Court clarified the procedural mechanisms of the statute and found that persons who are confronted with forfeitures ought to be afforded notice by way of a show cause, advance notice, a jury trial.
Where do you get jury trial?
I'm sorry?
Where do you get jury trial? I read James and I didn't find jury trial in James. Where do you get jury trial?
In the, actually, if I just have a moment, Judge,
Yeah.
to look at I have some outlines here of the statute. It does talk about trial. I'm looking at Section 6. I'm just cherry picking some words. And
I mean, a judge can have a trial without a jury.
Judge, I disagree with that.
You can't, there's no such thing as a bench trial?
Excuse me?
There's no such thing as a bench trial?
Oh, there is such thing as a bench trial, but what I'm saying is I think that...
Section 3 says the judge, the court or judge, and then it says a trial, and the James decision says the judge should hear evidence to make this decision. The judge makes this decision.
I understand that, Judge. My understanding of the statute is that defendants were entitled to a jury trial, and if I could
That's
be
your
heard...
understanding? Is
Well,
there any,
could I-
text or to...
Yeah, if I could answer, Judge.
Okay.
If you take a look at Section 8 of the statute, okay, and under Section 8, it says that proceedings in Superior Court, I'm reading the text, including right of exception, shall conform so far as may be proceedings in a criminal case. I'd suggest to the court that under Section 8, criminal procedure applies. Based on that, Your Honor, if criminal procedure applies, I direct the court's attention to Chapter 263 and Criminal Rule of Procedure 19, all of which talk about the right to jury trial, embodied in Article 15 of the Massachusetts Constitution. And from there, Your Honor, I would suggest that if there is to be a waiver, as the Commonwealth is arguing in this case, there should have been a written waiver following a colloquy. We see this routinely in any criminal case. So on that basis, Your Honor, I suggest, and frankly, Judge, it's a good question. I read a number of cases. I know I've seen jury trial, Judge, and I'm embarrassed that I can't give a...
Section 8 wasn't bad. Your quote from Section 8 wasn't
okay,
bad.
Okay, Judge. But I think to further my point, I'm pretty sure the language there in the case law. And so in any event, I would argue that in light of James, and to be fair to the defendant in this case, you know, this was submitted on memos of counsel, Judge. There were no affidavits submitted by the Commonwealth. They did rely on search warrants. They relied on police reports and whatnot. So there wasn't the opportunity for cross-examination to develop themes such as, and let me give you an example, Your Honor. Two of the items that were seized were a Confederate flag and a Nazi war helmet, which were characterized in my memo as historical artifacts, collectibles. The court deemed those items to be presumably offensive, and it's just, I'll get to the issue later, in violation of the public interest, etc. On the other hand, we all know that things like that are legal to possess.
They may be legal, but they still could be against the public interest.
If I could be heard on that, Judge, isn't that the fact decision that has to be made? In other words, to give a defendant a chance to say, look, we got this thing 20 years ago at a show somewhere, or a historical event, versus the immediate inference without supporting evidence that somehow it is offensive. And keep in mind, Your Honor, in this case, there was no evidence that the victims of the civil rights violations ever saw these things, ever knew these things existed. They weren't displayed. So, again, and I'll get to that later on the public interest issue. But my position, more succinctly put, is I read the statute, and look, there is a dearth of case law here. Okay, counsel said that the SJC solicited amicus briefs in February 2023. I think that was before the plea in this case. That wasn't on my radar at the time. I was trial counsel in this case. I read James after this appeal, and I'd suggest
although
that
sections 4, 5, 6, 7, and 8 were on the books.
Since 1870.
Right. I mean, so you could have read those.
I could have read those, Judge, absolutely. But in looking at the...
And the point is that a recent case of ours, it's also on it for FAR, but it's the Pierce case, it's a state habeas case, and it says that the clairvoyance exception applies to changes in constitutional law, but it doesn't apply to statutory construction, because the statute has always been there, and it's always meant the same thing, unless there's some switch of mind in the Constitution that changes the meaning of the statute. But this was just kind of a plain reading. In fact, the James decision goes on, this is to say this has always been the case since 1870.
Right, and it begs the question why the SJC was asking for amicus briefs to answer these questions before this case was decided. And, Your Honor, might I point out, it's not cited in the briefs, but I'm very familiar with the line of cases in Granada. I was just in this court 2 days ago arguing a Second Amendment issue. And the Second Amendment has been around probably since before 1870. And it was only recently that
They actually changed the interpretation of it. There were case law interpreting it one way,
right,
and then they actually switched it. Baldati doesn't even talk about sections 4 through 8. Baldati just proceeds without noticing sections 4 through 8.
Well, I think Baldati indicated and confirmed the point that I'm trying to make, is that a defendant subject to forfeiture is entitled to these procedural safeguards, and insofar as that did...
I'm sorry to interrupt, but the procedural safeguards, you had notice, right? There's no issue of notice, right? I mean, you had notice, you filed a response, you argued it.
Right.
The only thing that's missing is the jury trial.
Yeah, well, we didn't get the notice that's required by the statute.
You got notice.
But it wasn't proper notice, Judge. If I could compare... I'm sorry, Your
It's a
Honor.
question for you.
I'm sorry.
By looking at the docket, it appears that the Commonwealth filed their motion, and then you immediately filed your motion for the return of the property. And just by timing, it appears that you did that, in response to their motion. And then there was a joint request of the parties to reschedule the motion. And so I'm not following your argument that you didn't have proper notice, because it appears that the judge saw that both of these motions were going to be before him. He most likely wanted them to be heard on the same day. They were continued over 2 months. So there was an opportunity to ask for an evidentiary hearing if you wanted one, to bring in witnesses.
Sure.
Correct?
That's correct, Your Honor. But if I could just refer back to Section 4 and what it says. It requires that the court, not the DA, that the court issue a notice under seal setting forth the substance of the complaint. That never happened. There was no complaint. What I'm reading into this, Your Honors, and again, there's a dearth of case law here. Is this a civil proceeding or a criminal proceeding or some hybrid? If this is a civil proceeding, there should have been a complaint issued, which would have triggered a time period under the civil rules of procedure. Under Rule 38, you get 10 days to declare a jury trial as to any issue trialable by right before a jury. None of those things happened. So what does a person do in this situation where the DA initiates it, not the court? There's not an order of show cause. The defendant did have a right under the rules of criminal procedure to file a motion for return of property. Right. In that filing, Your Honor, what you'll see is an opposition to the Commonwealth's motion to forfeit, along with the defendant's motion for return of property, which is allowed by statute. Again, this does raise, Justice Massey, if I get back to your comment earlier about does this raise a constitutional issue, I suggest it does. The dictum in all of these cases talks about the strong constitutional protections given in cases where property is to be forfeited. And Article 15 talks about the right to a jury trial in these situations. So,
Nick, do you think that the proceedings, the forfeiture proceedings in 94C for drugs, have any analogy to these forfeiture proceedings?
I did see a case cited in the annotations under 276. I think it's one Chevrolet or something like that. And just based on my own experience, I've handled a few of those. It's typically a separate civil complaint filed in the Superior Court. We answer the complaint. We have discovery. We can make a jury trial demand. Okay. So if it is analogous, then I'd say that cuts in favor of the defendant in this case having.
Actually, no, the reason I ask is not who is in favor of, but if we're trying to figure out what this all means, like where do we look? Like can we look to 94C as an analogy? I mean, Ben, you just pointed, that says that's supposed to be civil. This one you said, Section 8, is supposed to be criminal.
Well, I'm raising the question, Judge. I'm interpreting under Section 8 that it's criminal, okay? That's my interpretation of it. But I also, in my...
And that's what you're asking us to do, to consider this to be a criminal
Absolutely,
procedure.
Judge, yeah.
Okay.
And not to muddy the waters, but I will. I was taking a look at the sexually dangerous person proceedings, and I think it's under 123, and I read some cases that talked about it being kind of this hybrid proceeding. I mean, for example, in this case, I think they made it pretty clear in either Beldotti or James that the standard of proof is by preponderance of the evidence. That certainly sounds like a civil, yet I'm looking at Section 8, and there's virtually no case law on this, okay, talking about it being criminal. If it's criminal, well, I say that, not me, the Supreme Court and the statute.
When you say jury trial, et cetera, is what you're saying?
Absolutely, Your Honor.
Okay.
Absolutely.
All right.
The other, if I could just, I see my time's running short, could I just touch on another issue? Your Honor, our position, and we argued this at the Superior Court level, is that, well, let me back up for a moment. This is not an appeal of the Superior Court order to forfeit the firearms, the ammunition, and the magazines. Those are intrinsically illegal. We concede 269-10E, judge had a right to do it, 276 section, same thing. That's not what is at issue with this case. What's at issue in this case is whether items not specifically described in the warrant are subject to forfeiture under this statute. And in looking at the language of the statute, it indicates that the court does have, I'll say, jurisdiction to forfeit items seized in the execution of the search warrant. Well, other than firearms, ammunition, the items seized were not seized in the execution of the warrant.
What about what about, you mentioned one of the things you want back is cleaning devices,
right,
loading devices. Are those mentioned in the warrant? Would those be?
No.
I mean, they're firearm related.
They're firearm related, absolutely, Judge. But the point that I'm making, and
You're saying they would not fall within the warrant then? If they're firearm related, that's not sufficient in your view?
That's not sufficient in my
Okay.
view. Okay, not sufficient to fall under the ambit of 276, Section 3. The items had to be seized in the execution of the warrant. Now, the Commonwealth is going to suggest that, well,
They were seized in the execution of the warrant.
that's what they're saying, and I'll concede that the warrant got them onto the property. At that point, I think it is pretty clear in the law, once you're on the property, things in plain view may be fair game. So they were seized based on plain view, not pursuant, or not in the execution of the warrant.
Well, that's splitting hairs there, aren't you?
Well,
I mean, that's the whole point. I mean, if it was, 10 kilos of heroin, you'd pick it up under the plain view doctrine.
But if
While you're executing the warrant.
Yeah, but if it was 10 kilos of coke or whatever, I wouldn't be filing this motion because those are inherently illegal to possess.
Yes,
Okay,
as a point.
Yeah, what I'm talking about, Your Honor.
And you have to talk fast, because although I asked a question, you're over your time.
Okay.
One last point.
Last one is on public interest. I think I did misstate something in my brief. I said the judge committed legal error. I think the standard would be he abused his discretion in finding that there was a public interest in forfeiting these items. I'd suggest when I read James, it doesn't, I think they start off saying that the courts have never defined what the public interest is.
Okay.
However, they applied some criteria, and I'll leave it to my brief. In my brief...
I think you can leave that part in your brief. You have it in there, and your time is up.
Unless there are any further questions, Your Honors.
I don't see any.
I think.
Hold on.
Would it be an abuse of discretion to say that it's in the public interest to seize the antique weapons because they could be used?
My answer to that would be that the judge, under Commonwealth versus Rufo, the court talked about the judge having an option to impose as a condition of probation certain conditions. And what I did suggest to the court, because at the time those antique firearms were legal to possess, the law's changed since then, and I suggested that the court could order that they be turned over for sale so that the defendant didn't lose the monetary value of those items.
Okay.
And
I think that.
Yeah, that does
great.
it.
I got it.
Okay.
Thank you.
thank you, Ron.
Thank you very
for
much.
letting me go a little over. Yeah.
Morning, Counselor.
Your Honors, may it please the Court, Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. I'll just acknowledge that the trial ADA who shifted positions on me, ADA Graham Van Epps, is also in the courtroom. As the Commonwealth argued in its brief here, Justice Pierce lawfully exercised his discretion in ordering that firearm accoutrements and certain items that connote a racist or anti-Semitic intent be forfeit in this case, in light of the defendant's plea to extensive violations of the firearms laws, to harassing and violating the civil rights of the only black family in his neighborhood over a period of many months. I think here there was a clear finding by the judge based on all the evidence in the record, and admittedly, while there wasn't witness testimony, although scratch that, there was testimony from a relative of Mr. Kasabian as to the ownership of certain firearms that ultimately were not forfeited. But
Was that by Zoom, or was that person present? I couldn't quite tell. Do you know?
It was not crystal clear to me.
Seems like it was Zoom.
I think it may have been by Zoom. I would also note, just as an aside, since you raised that question, that while my brother suggests that, for example, his mother might have had something to offer to the court, if you look at her affidavit that was included in the record appendix, she clearly was present, either virtually or in person, for the hearing as well. So the Justice Pierce did authorize witnesses, or voir dire, however you want to characterize it, to give testimony, at least as to the ownership of certain firearms that ultimately turned out to be the property of Mr. Kasabian. There's no indication he would have limited a request for example, the defendant's mother to testify to the things that were contained within her affidavit. There clearly was a mechanism for individuals to offer testimony or answer questions in that hearing, even though it wasn't a trial. Although the Commonwealth's position, as argued in its brief, is that here a trial would not have made a difference. And when we're looking at this under a substantial risk of a miscarriage of justice standard, we have to ask that question: would this have made a difference in this case? The defendant...
Well, it might have made a difference if it wasn't just a trial presided over by a judge, just a bench trial. If it had been a jury trial, how can we really say?
Well, I guess the Commonwealth would dispute the contention that a jury trial is what is envisioned. I don't.
Clearly, but for example, if that would be the case, as your brother argues, then I think there would be a difference. That's all I'm trying to say.
So,
without holding you to anything on there, but that's...
Understood.
Okay.
I think the position that the Commonwealth advocates in its brief still holds, in the sense that the defendant hasn't identified, for example, who he would call or what evidence he would present that would have been any different
I see your point. Okay.
than what was advocated in his memorandum seeking the return of his property. Even in his motion to stay the execution of Justice Pierce's order, which I apologize I didn't include in my supplemental record appendix, but which can be accessed via the trial court docket, he essentially reiterates the same arguments he made in his initial motion for return of property, and the same arguments that he is raising here on appeal. In none of those documents has he ever affirmatively requested a trial or indicated who he would call or what different information would come out if there was one. So where the issue is waived due to the failure to raise it, I do think that's important to note, that in James they did address waiver, and the judge had kind of sort of reanimated the issue there at the trial level before it reached the SJC. So it was preserved because the judge had, on reconsideration, reached it. Here, there was never a motion for reconsideration subsequent to the James decision. There was never any sort of filing below suggesting that this should have been revisited in light. It's just an argument being made on appeal. So it is waived, and this court does view it under substantial risk. And here, the only other...
Was the stay granted?
I'm sorry? The stay
the
was
stay.
granted,
Okay.
yes. So the property has not been destroyed. The last main point I just want to make before I'll rest on my brief, unless your honors have any questions, is this is not a case like Salmons or James where there's some sort of dispute about the property, where there are material facts in dispute about the property, or about whether the defendant would use that property in furtherance of future crimes. Here we have, as the Commonwealth includes in its supplemental record appendix and cites in its brief, numerous jail calls by the defendant after he was arrested, in which he discusses with his parents both his decision to rearm immediately if released, and also to conduct not just additional but more physically violent harassment of these victims if released. So this is not a situation as in James or Salmons where, like in Salmons, for example, the court said, well, there's no evidence that the defendant would use these one or two videos or images on the cell phones to commit further crimes. We would know it was him immediately. He would be prosecuted. The victim would know it was him. This defendant, on record, on recorded calls, indicated an intention to violate the firearms laws again and to violate the civil rights of the victims again. So we know that if these sorts of things are returned to him, that they are going to factor into an intention to commit future crime. They're not just relevant to his past crimes. So I would, for all those...
Can you make a distinction between the different items here? In other words, when you say that, are you referring mostly to the items that are in firearms related, so to speak, or the other items like the flag and the helmet?
So obviously the two main categories of items that we're talking about that would be in dispute are the firearm-related items and then the paraphernalia that has either racist or, that can have racist or anti-Semitic connotations. I would submit to the court that that the Commonwealth's argument pertains to both. As to the firearms items, I think it's a little bit clearer in the sense that this defendant since the mid-90s has been ineligible to possess firearms. He had assault weapons and a variety of other illegal firearms in his possession. He's not supposed to have those. There's really no reason for him to have any materials that are part and parcel to the possession of.
Would that prevent him from having, antique weapons?
So at the time, I would say it did not, right? We've acknowledged, the Commonwealth noted in a footnote, and this court sort of acknowledged earlier with my brother, that now those actually, some of those would be illegal. I think here, as ADA Van Epps argued at the forfeiture hearing, those are still weapons that can shoot and kill and harm people, and here this defendant has demonstrated a flagrant disregard for the law and an intention to do just that, to harm other people, to harass and violate the civil rights of other people. So I think it was within Justice Pierce's discretion to conclude that those items should not have been returned to him. And then just to close the loop as to the second category of items, I would just note that if you look at Beldati, and I had it here, I don't want to misquote it, the quote says, items, quote, can be seen as being directly related to the defendant's illegal acts, as having influenced his behavior, or as being relevant to an understanding of the psychological or physical circumstances under which the crime were committed. Certainly, the Nazi helmet, the Confederate flag, these medals and other items that were seized were relevant to the intent of the defendant in harassing and violating the civil rights of the victims. In a vacuum, just throwing banana peels onto someone's property repeatedly might not seem that incriminating or culpable, but these things would have been essential to any prosecution. They would have been key to proving the defendant's intent. They are the kind of things that animate his worldview and his desire to commit these crimes, and particularly, again, where he expressed on numerous jail calls an intention to reoffend and to harass this family further, even to a point of actual violence. I don't think it was an abuse of Justice Pierce's discretion to conclude that he should not possess these. Not that they're generally unlawful to possess. People have a right to believe what they believe, and these things are not inherently illegal. But on the facts of this case, on the record of this case, it was not an abuse of discretion.
Wasn't the stuff in Beldati more stuff that was more illegal? Kind of, obscenity,
So some of it was. Some of it, I believe, qualified as child pornography, and some of it was obscene in the sense that it was sexually explicit videos. But there were also sex toys and things of that nature that are not inherently illegal, but that the defendant had used in the commission of the crime, and that the court found were intrinsically tied to the commission of the crime in that case.
Does that really apply to like a Confederate flag? I mean, you do have a right to expression.
Again, the Commonwealth's position is not that we should be seizing all Confederate articles or Nazi paraphernalia from people who possess them. You can possess those things, you can believe what you believe. When you choose to act on those beliefs and you choose to take steps that this defendant took to harass individuals in your neighborhood, to express an intention to continue to do so if and when released after being charged with over 100 counts of illegal firearms possession and firearms crimes and the violation of those individuals' civil rights. In those circumstances, I don't think that they need to be returned, and I don't think it's an abuse of discretion.
Is there any need in this case to have more testimony, even expert testimony, to explain that what you call the intrinsic tying of these objects into animating or being part of this defendant's worldview?
Again, setting aside the fact that the defendant hasn't suggested that in any of his filings or identified what that testimony might be, on the plain record here, I don't think it was necessary. The defendant's statements on the recorded jail calls used the N-word, used other derogatory terms for these individuals in describing his victims, expressed in...
It's pretty clear what we need not say more other than look at what he had to say, right? That part I think is evident. What I'm referring to, though, is the connection between those items and that worldview, how much information needs to be developed with respect to that particular connection. What you've answered,
I'm not sure what an expert, short of like a mental health situation where they would interview him and get his interpretation. I don't know how you could reach into his mind and know. So I'm not sure what an expert would add.
Any time a judge or jury has to determine intent is basically what you're saying.
Yes.
And you do so on the facts of the case and what's circumstantial and otherwise. This would be a point.
And again, just because the Commonwealth isn't disputing that some people possess these things and that we can't just go around breaking into their house and taking them away from them, because I may personally disagree with the principles that they stand for. I think it's intrinsically tied to the facts of this case and the record that was before the judge and the search warrant affidavits, in the jail calls that he reviewed, in the motions in limine before the defendant decided to plea, in the admissions the defendant made at the plea colloquy, and in the facts that were set forth in the competing motions of the parties before Justice Pierce held his non-evidentiary hearing.
Okay.
So assume that the clairvoyance exception does apply and that the issue isn't waived. Is there a right to a jury trial?
Well, I still don't agree that there's a right to a jury trial. I think the Commonwealth would be in a much tougher position in arguing that the defendant, that this was harmless beyond a reasonable doubt. But again, I'm just going to fall back on the fact
So why isn't there a right to a jury trial?
I don't think I don't see anything in the statutes or in the case law or in James that suggests that the trial is the trial can be won by a jury. In the forfeiture context, we're typically talking about trials before a judge. I understand that. To sort of refer back to a question you asked my brother, I'm not sure this is governed by 94C or any of that. I see parallels in the sense that we're talking about in rem proceedings to dispose of property, but in those parallel sort of proceedings, we're typically talking about bench trials before a judge where a judge makes findings of fact. I don't see anything in the case law or sections 4 through 8 of Chapter 276 that suggests that you're entitled to a jury trial. But what I was about to fall back on again, at the risk of being redundant, is the defendant hasn't identified what evidence would be presented or suggested that any different evidence would be presented. So, I mean, that would be the Commonwealth's argument about why it would be harmless beyond a reasonable doubt if the clairvoyance exception applied. But again, for the reasons stated in the Commonwealth brief, I don't think I need to articulate them here. I think Your Honor actually articulated them fairly eloquently to my brother. This is not a clairvoyance exception. The defendant waived this. He didn't raise the issue below, and so we're in substantial risk of miscarriage of justice land.
If there was a jury trial, the jailhouse tapes would probably be introduced?
Certainly aspects of them would be introduced. I want to be candid with the court. Justice Pierce was not going to allow all of those jail calls in if there were a trial. They were certainly going to be circumscribed to an extent. But I do think that in this jury trial, the Commonwealth would have a stronger argument because it's not odious statements the defendant might have made reflecting prejudice and animus towards other groups would be much more relevant at this stage of the proceedings in terms of whether those things should be forfeited than it would be to the main issue at any jury trial had he not pled guilty, which would have been his unlawful possession of these firearms. So if there are no further questions, I'll see the rest of my time, rest of my brief, and ask that you affirm Justice Pierce's order.
Let me check. Thank you both very much for the arguments.
Thank you very much.
They were very, very helpful on both sides. We appreciate it. One more case?
Yeah.
We're going to hear one more case before we take our morning break. And the next case is, Commonwealth versus J. Aaron Smith, 2024-0037. Good morning.
Good morning. May it please the Court, Ann Maurer for Mr. Smith. I intend to only address the first argument in my brief today with the Court's leave. When the trial judge denied Mr. Smith's Rule 17 motion for third-party therapist records, he abused his discretion, violating Mr. Smith's right to a fair trial by imposing a standard that is all but impossible to meet. The Supreme Judicial Court in Dwyer found that to require the movant, the defendant in that case and in this case, to divine the specific information that would be found in privileged records was essentially imposing a court mandate that threatened to impede the defendant's right to a fair trial.
Could you make it clear for me what information was provided to the motion judge? Because I read the motion, I read the transcript, and it's not clear to me the foundation of the argument.
Okay. So trial counsel in this case, in her motion, which is on page 27 of the record, states that it was reported to the police on February 6, 2021, that in the 51A report provided by the Commonwealth, there's a notation dated such and such date that states that the victim's mother informed staff she met with Morgan Powell,
So we have a 51A report, which is just a report into DCF by a third party, right?
Yes.
Okay. And it says, there is a notation dated March 2nd that states, CB's mother informed staff that she met with Morgan from FAC for individual therapy. But there's no date of when the therapy was, what the reason was.
Right, the mother informed in the 51A report that her daughter went to therapy at the Family Advocacy Center, which is a place designed to provide therapy specifically for children who've suffered abuse, and that she received therapy there. In the record during oral argument, page 39, trial counsel states explicitly, she's being referred to therapy based on these allegations. That's the reason for the referral. She admits to the court, of course, I don't know exactly what she talked about, but we know that the victim in this case was referred to therapy at the FAC, which is, I think, an important point, a place designed to give therapy to children who've suffered abuse.
How does the trial judge know that? I mean, Justice Allen wouldn't know that if you had presented it to her, what the FAC was, but would the motion judge here have known that?
Certainly, Judge. The FAC is a place where they do the SANE interviews. I think every trial judge in the Commonwealth knows what that location is and what kind of services they provide there. So the counsel here made a very explicit factual record about what happened in this case. This child received therapy to address the allegation of sexual abuse.
Well, I mean, that's a jump, though, right? That it was to, I mean, the family's being broken apart. Family Advocacy Center could have been for anything, right?
The mother told
that she's met with Morgan Pell for therapy.
yes, she was referred there because of the allegations of sexual abuse.
Is that in the record?
Well, it's in the argument by counsel.
Okay.
Was the judge given the actual DCF record?
No.
And should we be troubled at all that it was only a 51A and not a 51B, given the evidentiary restrictions of a 51A?
No, the trial counsel made the factual record that she would need to meet the Lampron standard. She showed that this victim received therapy because of the sexual assault. And this is different from the cases that the Commonwealth relies on in order to ask the court to affirm the ruling below. In Oliveri, for instance, the victim had already been seeing a counselor, and her medical doctor advised her to discuss the allegation with the counselor. But in that case, there was no indication that the victim actually did see the counselor again or speak about this. It was just we knew, counsel in that case knew that the doctor had advised her to seek counseling. Here we know that the victim actually sought counseling.
So is the import of your argument that any time a sexual assault victim gets therapy, it's fair game?
No.
Well, what isn't that just what your argument is?
Anyone that goes to the FAC is fair game?
If we know from the record that the person was referred to therapy because of the sexual assault allegation, yes, that should be enough.
So anybody who goes to a sexual assault counselor for a sexual assault, their records are fair game?
Within certain timeframes of the allegation.
The Commonwealth argues that destroys the privilege.
No, Your Honor, it doesn't, because the cases where this court and the Supreme Judicial Court have denied or affirmed a court's denial of a Rule 17 motion, it's in cases where, for instance, maybe there were other therapy-related reasons why the person was seeking counseling, that's Oliveri, or, for instance, in the Commonwealth relies on Seeley, where the victim, for immigration-related reasons, tells a family member that she doesn't want to go to the police. The family member sends her to the Boston Area Rape Crisis Center. And when she gets to the Rape Crisis Center, the movement is able to say that she was then referred immediately to the Victim Rights Law Center. So in that case, there's actually no indication in the record that the victim received any kind of substantive counseling from the Boston Area Rape Crisis Center. She went there because she had this legal concern. They referred her to a lawyer, and there was no indication that counseling had taken place there or that she had even described her specific legal problem to them. So when counsel moves for the records, he doesn't know that she in fact has seen a counselor at the Boston Rape Crisis Center. Unlike here, where we know that the victim has seen a counselor.
But we have no idea what was discussed, what was raised, whether or not, as the justices both have questioned you about, where's the basis for saying that there's going to be something there that would be helpful to your client when all we have is the referral?
Well, Judge, importantly, the trial counsel does not have to show that the information in the files is exculpatory.
Well,
she needs to show that it's relevant.
Right, but here, to show relevant, the issue has to be addressed, right? Something has to be said about the allegation.
She would have to have convinced the court that the victim spoke about the offense.
Right.
And in this case, when we know she was referred in order to speak about the offense, that is enough to meet that burden under LAMPON.
Why would that referral, back to Justice Massing's point, you get the referral because of an allegation or whatever, or because, for whatever reason, and the assumption that you're going to talk to the counselor about the very issue that got you into therapy in the first place. If that's an automatic assumption that's valid from your point of view,
in order to meet the relevance question,
then it would always be relevant. You would always meet the standard.
In not one of the other cases, except for LeBron.
And maybe that's law. I'm just saying, but you would always meet the standard in that case.
Yes, because the whole reason why Dwyer was concerned about the prior protocol is that we cannot know exactly what was stated. And in that case, before Dwyer, when people had to make out an exculpatory reason to get into the file, then of course we were hypothesizing what we would find.
Right.
We can't know that. But if we know at a minimum that this is the reason that the therapy was sought, that has to be enough because we can't know anymore.
And those therapists are mandatory reporters, yes?
Yes, I believe so.
And was a report made by that therapist?
She had already reported. That's why she was going to the Family Advocacy Center.
The therapist had filed a 51A?
No, the victim had already spoken with the police, had a sane interview at FAC, and then was referred for...
But just because there's a prior referral doesn't absolve a mandatory reporter from making a report, right?
I reviewed the discovery in this case. It's outside of the record, certainly on appeal. I did not see another report. But I don't know that that's true, Judge, that if the FAC knows that the victim has already been in contact with police, they performed the sane interview with the DA's office at the FAC, I don't know that they would be required to make, every time the victim discloses to them, I don't think they're required to make more, to file a 51A every time, because she had her sane interview at the FAC. If there are no further questions.
I have a question on the one of the other issues, which is you argue that in your argument that having your client present at sidebar for the individual voir dire would have made a difference. One of your arguments is that it would have affected the number of peremptory challenges that were given. The judge gave the wrong number of peremptory challenges, and somehow if your client was present, that would have changed things. My question is, are you making a claim? You're not making a claim. I don't see it in your brief that we should consider the wrong number of peremptory challenges to be reversible error.
No, Judge, I did not make that argument. I think my point with respect to that was just to show that to lend some color to my argument that counsel was not quite on top of what was happening or what she was allowed to be doing at that point. Not to say that I don't think we could show prejudice on that, so I didn't raise that.
Thank you. I see no further questions. Thank you very much for your argument.
Thank you.
Commonwealth?
Good morning, may it please the court. Assistant District Attorney William Joyce on behalf of the Commonwealth. The Commonwealth respectfully requests that this court affirm both the motion judge's denial of the defendant's Rule 17 motion and the defendant's overall conviction. Addressing the Rule 17 motion for the victim's therapy records, the motion judge did not abuse his discretion here when he denied the motion because the defendant failed to meet his threshold burden under Lamprana and Dwyer of establishing both the relevance of those records and that his motion was not a prohibited fishing expedition. Now, multiple decisions from both this court and from the SJC, which counsel addressed some of them, such as Seeley, Olivier, Bourgeois, and I think Jones is the other one. Those cases emphasize that a request for a victim's therapy records based solely on the timing of when a victim was referred for therapy after an assault is insufficient to establish relevance. Rule 17 is not a discovery tool, as this court is well aware, to be used to conduct a fishing expedition in the hopes that records might contain relevant information, and the Commonwealth submits that that is what counsel was attempting to do here. We don't know what the victim said during therapy. Yes, she was referred after these allegations, but she might have decided not to talk about this incident at all. She might have decided to talk about...
But how can anyone ever know exactly what's said until they get the records?
Well, there are instances where that is true, either because the therapist reports, maybe the victim herself even says something. That's the That's the Lebrad case, where there was some affirmative information that the allegations were discussed during therapy. Now, I'm not saying it needs to be a full-on admission, but there needs to be something more than just after a traumatic incident, someone is sent to therapy. Because during that therapy, they could decide to talk about anything. She could have talked about school issues, dealing with ADHD, the fact that this was tough on her family. We don't know. And as a society, we want people to be able to go to therapy and talk about these issues freely without fear that they're going to be dragged into court and asked about those issues.
Could you address the issue that your sister brought up regarding that sort of everybody that in the proceeding knew that this facility was where the SANE interview occurred, and that seemingly it was presumed that this would be relative to this incident, that she would have had this therapy, that would have been the content?
You mean the Family Advocacy Center, Your Honor?
Yes.
I would tend to agree that that would be a well-known institution, at the very least in county, where this judge regularly sits. Despite that, again, just because she was referred to therapy doesn't mean that she had to talk about this incident. I'll also note that the request was for 2 years of therapy records.
I'm sorry, would that be enough? Like, if there was some information which they somehow figure that somehow there's a leak, a 51A report, that the conversations did involve the allegations here. If there's evidence that the conversations involve the allegations, is that enough?
I'm sorry, Your Honor. Can I ask to just clarify a little bit?
If there's some, I'm sympathetic to the claim that it's hard for the defendant, and just as Vuono said, to know what's going to be in the records, whether they discussed anything when they can't see the records. But if there's some external evidence that there was discussion of the incident, would that be enough to at least get the counsel to be able to review the records?
I would tend to agree with that, Your Honor. Again, what that actual threshold is going to be fact-specific. Here, there is no information that these allegations were ever discussed during therapy. Again, it is outside the record of this court, but I will say the counsel's representation during the motion hearing of what that 51A report contained is accurate. All it says is she was referred to therapy. there's no more discussion of anything else about that.
Would those kinds of referrals be standard in your experience? I mean, the person can be referred and not necessarily take it, not go, right? So when the 51A says the person is referred to, would you view that as something that happens in every case? And then, of course, it would be up to the alleged victim to take advantage of that opportunity or not?
I will apologize, Your Honor. I actually don't know the answer to that question.
Okay.
I don't deal with these cases very often,
Okay.
and I didn't have the opportunity to ask that sort
That's
of
all right.
question to trial counsel. But I will just paraphrase it a little bit from Jones, and this is cited in the Commonwealth's brief, that to accept the defendant's argument that the records would be relevant both because they might contain information about the assault and because they might not, would render certain statutory and common law privileges meaningless. I will also say, if this court does decide that the motion judge abused his discretion in denying this motion, the Commonwealth would agree with the defendant's request to remand the case down to the lower court for additional proceedings. Unless there are any other questions that the panel has. Commonwealth with the
Don't
rest
see
on its
any.
brief.
All right, so thank you very much. Thank you both for your arguments, and thank you for answering all of our questions, sometimes more than once. I appreciate it. Okay, the court will stand in a morning recess.
All rise.
Sorry.
Rise. Court is now open. Be seated.
All right, the next case on our list is Theodore Machri versus Sheila Mary Cummings, number 2024-0772. Good morning.
Good morning. May it please the court. Matthew Barak for the appellant Theodore Machri.
I'm going to have to ask you to talk into that microphone
Oh,
right
excuse me.
away. As close as you can get that microphone to your speaking voice, that the better for us.
Very good. May it please the court. Matthew Barak for the appellant Theodore Machri, the father. The appellant respectfully requests the following. 1, to vacate the judgment as it pertains to college costs. 2, to vacate the judgment as it pertains to the Unima account. And 3, vacate the order of attorney's fees. I will address each argument in order. First, the lower court did not address in the judgment that the mother failed to consult the father regarding the choice of college. This was entirely ignored within provisions of the findings and within the decision regarding the allocation of college. And I would point out to the court that this court has held in Mandel that in determining college costs, a relevant inquiry is to the extent to which a party may have been excluded from the process. And there was testimony here by the father that he was not involved in the selection of college, that he was not involved in the allocation of costs, and nor is it contained anywhere in the judgment. The judgment is entirely silent on that point.
On what point?
On the
The judge says that was not substantiated, that your client was aware of the college choices and pointed out the fact that your client's sister was one of the college advisors. Am I misunderstanding the finding?
The transcript has that the sister was involved to a certain extent, but what was not involved was this. My client was never informed of the cost regarding college until after the fact, until after the decision regarding Bucknell had been determined.
Couldn't it not be inferred that your client would know the cost of Bucknell University?
No, but he should have been consulted because it's a deficiency within the judgment that he was not part of this decision to attend Bucknell.
So wasn't his sister assisting the child?
To a certain extent, yes.
To what extent?
The sister was involved in doing the earlier part of the applications. The sister was involved in doing essay review, but she was not involved with the cost part of it. And the ultimate choice, the sister was not involved at that point in time.
So he was aware that Bucknell was one of the schools that was on the table?
I'm not sure if he was.
Oh, he was. He testified to that and talked about the early decision and things like that, so he was aware of that.
He was aware of it, but not to the extent of the costs.
So you really, now I hear your argument being much more limited than what I understood to be in your brief, which is not in a misunderstanding or being left out of the process of choosing the college or university, but not being brought in specifically on the cost.
Correct.
Okay. And again, I would go back to the fact that having paid already the costs of private school up through high school would likely have been aware of what the amount would be to go to a private university.
I see your point, but my concern is the lack of being included regarding the selection in choosing a school that is not a public school, that it's a private school, and that certainly we can surmise that Bucknell is going to be more expensive.
Did your client at all testify anywhere that he wanted or had advised his son to think about a public school? I didn't see that.
No, I think that their relationship at that point in time was fairly fraught. And there were times when he was trying to reach out to him and discuss things, but that didn't happen.
Wasn't the order based on the cost of attending UMass?
Yes, Your Honor.
So what's the prejudice?
Well, here, the concern here is that I'll move to sort of my second point. Under the child support guidelines, the court needs to consider the costs, which we've discussed, the aptitude, the living situation, the availability, but critically, the resources of each party, the parent, the child, as well as financial aid. And here, because he was left, my first point is because he was left out of the college costs, he wasn't involved in any application for financial aid or whatnot to a private school. But more importantly, and more critically to me, is that the resources were not addressed by the lower court in the allocation of colleges. The resources, when you read the judgment, are fundamentally all about his obligation. There's nothing in the judgment of the lower court regarding the income of the mother, the income of the father, the debt disparity between the two parties, the assets of the parties. And I would submit that the trial court was required to make...
Why does that matter if the obligation of your client is capped at the UMass level?
Because contribution is not presumptive. There's not an obligation to pay for college. It's a discretionary factor. And the lower court has an obligation under the child support guidelines. The language is the court shall consider the resources of each parent, child. That's a shall. So here, when we read the college cost allocation determination, the court left silent the disparity in income between the parties. I mean, at the time that this was awarded, and what the court found was that Dad had resources that had diminished. He had $1 million left, that he had diminished his resources and paid $500,000 for private school education over the course of the child's lifetime before he went to Bucknell. That Mom was at $4.5 million. Mom's income had increased. His income had gone considerably down from what it was.
Am I misunderstanding the record here? It looks like Mother was responsible for probably 3 of the years of college. Father was responsible for 1 semester, and the UTMA was the other semester.
Well, not exactly. The first year of, well, yes, the first year of college, I would agree. First year of college was paid by the 529, which had about $86,000. And so Mom thereafter was responsible for the rest.
And so isn't that implicitly taking the incomes into account? Doesn't that, that sounds like a pretty good allocation mostly for the mother and not to your client?
Yes, but I agree, but I think the issue that I have is that the court didn't lay that out. They didn't make findings regarding the resources of each parent at that time. I think the court, when you read this judgment, was trying to come up with a reduction, which they did, but they didn't go through the analysis that's required under the child support guidelines.
But your client was not made responsible for paying anything but for that once for the last year. No matter what happened in terms of a more complete analysis, in the end, that's what your client is responsible for, right? 1 semester.
Give or take, because it's
basically 1 semester.
Yes, I don't disagree with that.
All right. Okay. He takes issue with the 1 semester, and I think we want to go on to the other account that was set up for the, apparently was, let me ask you this, the other account that was at issue here, at the time of trial, the child was 20, turned 21. Did the money go to Bucknell or not?
The UDEMA account?
Yeah.
Yes, ultimately it did.
Okay. So what is it your client's looking for right now?
A reallocation of the college based on the income of both of the parties. And
no, that particular account.
On the UDEMA.
What's the
Here's it's an excellent question. Like what happens? I think that first, to me, it shows the concern regarding the misapplication of the college costs, because what the judge didn't do.
What does your client want us to do with respect to that account that's now been given to Bucknell? And now I'm assuming that the child has graduated.
That part of it should be vacated because
it should be vacated
because he wanted the money to go to to go to his kid directly. And the reason why is
And what would be the result of that if we vacate it? How does that?
he's willing to take the consequences on that. And the reason why is it's a personal reason. It's not necessarily a legal, artful legal reason, although I think the UDEM account legally should have gone directly to the child. His family had put money aside into the 529 accounts. That's where the funds went. The UDEM account.
I think I'm understanding you to say that you would like us to issue a ruling that although it has no legal effect and doesn't really do anything legally, it just would be meaningful to your client. Is that what you're saying? Is that what you're saying?
More or less. I mean, he would, if it was vacated, I think it would go along with the issue related to the allocation of college, which one could say, well, that might.
We don't, that's not usually how it works. I mean, usually when we vacate a judgment, it's because there's an error of law, there's abuse of discretion, and there's a consequence to it.
Well, there's an error of law here because the UDEM account, he was clearly 21 at the time of the judgment. Under the provisions of the UDEM account, the child should have received the money directly. But also.
Does it make any difference to the fact that at the time of trial, the child was not yet 21?
Well, by the time the judgment issued, he was.
Correct.
So I think that is the difference. I think at that point, the judge lacked authority to order him to pay it to Bucknell.
Okay.
But see, I think that's the other way to look at this to me, is it goes back to the child support guidelines point, which is that the judge must look at the individual resources of each party. So the judge could have considered the UDEM account as the child's contribution and gotten to the same result by not ordering it. Because it's the same effect. I can't argue that.
Right. There was testimony that had the money gone directly to the child, that would most likely have been used for college expenses.
I think that's correct.
Yeah.
I think that's correct. I can't quibble with that.
So the account at this point has been transferred to the son. It's been used.
It was transferred to Bucknell per the order of the court,
Okay.
yes.
So it's gone.
It's gone. Everything's been paid. Every obligation.
And you don't want it back. So it's. I mean, isn't the provision with regard to the UTMA? Is that how you said it?
Yeah.
Moot.
Is it moot at this point?
Yeah.
Yes. I mean, it's been paid. I can't argue that that's not a moot issue. I concede that.
And there's no issue. There's no issue of a contempt or anything like that.
No, everything has been paid. All the judgment has been wholly satisfied, including the last point, which we'll spend the last 2 minutes on, which is the issue of legal fees. The issue with the legal fees is pretty simple. There's no question this has a long, torturous history. There's no question that this case has been highly litigated. But I would just submit to this court that, we have an expression in divorce law. A 10 doesn't marry a 2, a 2 doesn't marry a 10. I don't think.
Say that expression again, I didn't quite get it.
You can use it as a parties this weekend. A 10 doesn't marry a 2, and a 2 doesn't marry a 10. These parties have been.
I've heard that one before.
It's one we use often.
Unless the 2 is really rich.
That happens too. The issue, my point is that these parties have been both litigating for many, many years. And here, the docket is not that I think it was inequitable to present the father as being the only one here that should have been awarded, that had to pay the tax of having a third trial in this case. I would just point out that the mother initiated the action. The mother sought support the very day after the unallocated support order expired.
There was a counterclaim, correct?
Yes, Justice Allen. Mother hired a vocational expert. She objected to the father's expert. She repeatedly changed her mind during the course of the litigation. My point is that it took both parties to get to where we are here today. It wasn't singularly the part of my client.
So the proposed findings were not provided as part of the record. Did both parties seek attorney's fees?
Yes.
And was it argued?
I wasn't trial counsel. I don't know if they actually argued the issue of attorney's fees, but it was both submitted that both parties were looking for attorney's fees.
Okay.
And then finally, just my last point on that is that the lower court did not, in making that order, review again the resources of the parties in making that determination. So to me, it's an inequitable tax, and I would submit that that part of the judgment should be vacated.
Okay. Any additional questions? Additional questions?
No other questions?
No other questions. I've checked with the panel. Thank you very much.
Thank you, Justice.
Good afternoon. May it please the court. My name is Rachel Sohn, and I'm here on behalf of SHEILA Cummings. I'm accompanied by my associate, Alana Manca. I'd like to start with the issue of attorney's fees. As your honors may have noticed, this case has been long-running. Although the parties were married for a relatively short time, they separated in 2008. While in Hong Kong, there was litigation surrounding custody and the removal of this child, Teddy, to the United States. Ultimately, mother prevailed, and there were appeals, several in Hong Kong, before mother was able to return to the United States.
We're familiar with the history of this case.
Teddy was 5 years old when
Just call him child.
the child was, well, he'll be 23 on Sunday. Was 5 years old when the parties separated, and as I said, he'll be 23. This case has gone on appeal after each judgment in this case, and my client has borne the burden of attorney's fees each and every time, not only trying the case now 3 times, but also relative to the appellate attorney's fees, and also responding to a request for a further appellate review.
Again, we're familiar with the case, but as Justice Allen pointed out, this began as a complaint for modification filed by your client.
So I'd like to discuss that because Judge Barber actually taxed my client in only awarding her $10,000 for the fact that she filed the complaint. My client was the custodial parent of the child. Now, the posture in this case is a bit odd because of the appellate action in the case. So the case began in 2011. There were 3 separate docket numbers because the parties were divorced. The case began in 2011, and at that point, the matter was pled. The case was tried in 2013, and a judgment was issued in 2014, at which point then father appealed.
Case was remanded. Well, yeah, again,
remanded.
we're familiar with the history of the case.
But the important part of it is that Judge Barber, the lower court, referenced mother's seeming lack to amend those underlying actions that were tried and remand relative to the child support issue, because the unallocated support was by its nature due to terminate on February 1st, 2018. The child was 15. Mother, as custodial parent, had an obligation to request child support for the support of the child. Now, father didn't do that, mother did, but by pleading the case, she should not be taxed for that particular pleading. She was simply doing so as her responsibility as custodial parent for the child. Father could have done it, he didn't. Mother did. She should not be taxed for that responsibility seeking to support this child. Now, what happened is that we had to litigate the matter of child support as father sought to essentially undo that which had been done at the trial court and affirmed by your court in the prior litigation. And so the issue of child support had to be litigated for that issue. It wasn't a matter of seeking the court's assistance on something, saying that there had been a material change in circumstance, pleading something new. It was a matter of support ending by its terms and a requirement by one of the parties, it just so happened to be my client, to seek the court's assistance in establishing a new support amount for the support of a minor child. So yes, she did seek the court's assistance in it, but she should not be taxed for that as it was her responsibility as a parent. Your
And
Honor,
when you say she should not be taxed for that, is your point being that she was entitled to additional attorney's fees?
it's obviously my position that she should have been paid for all of her attorney's fees, that we took that position at the time of trial. In particular, the judge notes that my hourly rate was much lower, significantly lower.
Let's focus on what's before us right now, which is the allegation that this particular award of attorney's fees is an abuse of discretion.
And what I'm saying is it's not. Just by virtue of the fact that she's the one who filed, she shouldn't be penalized for that.
That's the answer to the question. That's what I was looking for. So as far as you're concerned, that's just not relevant.
It's not relevant.
Okay.
No, it's not relevant. I don't believe that it is.
All right.
But what's more, we've requested appellate attorney fees in this case. And it's our position that none of Father's arguments on appeal are valid. Neither the attorney's fees, as I've just answered, the UTMA accounts, which Father's counsel has admitted is now moot, as was moot at the time of filing the appeal, and the issue of repayment of private school tuition by way of a credit against Father's college costs, none have any merit on appeal. Nonetheless, my client has suffered the burden, yet again, of filing or responding to an appeal. And so we have requested an attorney's fees, and we think at this ultimate time, this now third appeal, that she should be granted attorney's fees. You've seen in my brief, and the case law supports an award of double fees in the event of a frivolous appeal, and that is what we're seeking.
Double costs or double fees?
Double costs. It does say double costs, Your Honor. This has been a hotly litigated case. Although Father testified at trial that he did not believe it was a hotly litigated case, it certainly, the record speaks for itself. And my client has expended enormous fees and time in responding to Father's requests. This one filing of mother seeking support for her minor child should not discount the number of times that mother has had to respond. Never mind the lengthy history outlined in the record of mother's legitimate attempts to resolve the case. I know you've all read the record and you understand the issue, but it's over and over again, mother's attempts to resolve the case have fallen short, and not to any fault of her own. So again, as to the issue of the UTMA account, that is moot. Attorney's fees, I don't believe that has any merit. And in fact, my client should be awarded appellate attorney fees. And on the issue of college, Your Honors noted that Father's sister, Alicia, was involved as a college counselor. I think the record is replete with references to Father's sister being involved, and therefore Father being involved, Father knowing of Bucknell. He never voiced an objection. There was no objection made. And as Your Honors rightly pointed out, this is a cost charged at a UMass level, not at Bucknell level. So,
do you think that it makes a difference that the trial court did not make specific findings relative to your client's income and assets?
I think the trial court did reference my client's income as it relates to child support, so it's in there. The court obviously considered the parties' respective earning capabilities related to child support, which is intertwined with college costs. And the court made reference to, and therefore made findings of, the parties' significant resources. Just because my client had more does not mean that Father did not have any. I think the record is, and the court finds that he had over $1.5 million at the time of trial, certainly had significant assets, and certainly enough to cover what his obligation ultimately was, which is a semester at Bucknell. So I think the court did. I disagree with my brother counsel. I think the court did make sufficient findings to carry its burden.
Okay. Questions? Any further questions? The panel has no further questions, so if you don't have anything else to add, we'll take the case under advisement.
Thank you. I'll rest on my brief.
All right, thank you all very much. Excuse me. Just give the panel a moment before we call the next case. This case coming up, apparently, we have some pending motions that were filed. We didn't get yet, so we'll just take a look at the last case. The last case is on the list of pending motion that was filed, and we just took it. I just see that.
I saw that there was a note in there.
Okay, I didn't see it, so we'll just have just look. All right, thank you for that. The next case is Paul Aspel Aspel, did I say it correctly?
Aspel, yes.
Aspel, okay, versus the Mortgage Electronic Registration Systems, Inc., number 2024-P-0874.
Good afternoon, or...
Nope, still morning.
Good morning, Your Honors. Thomas Campbell, I represent Joyce and Paul Aspel, the plaintiffs below. The question is, what is the standard for overturning a jury-waived trial verdict? And the Brewster wall covering line of cases says that if there's no rational basis in the record for the court's finding, the judgment should be overturned. I don't think there's any dispute between the parties on that issue. Where we do differ is the question of whether or not there was evidence that was sufficient to create a dispute. And it's our position that any reading of this record at trial shows that there was, in fact, no evidence disputing the fact that my clients were entitled to an easement by prescription over the entire area and an adverse possession over the entire area. I'll start with easement by prescription. All of the evidence in the case was that the Aspels used the entire disputed area. It's a strip of land that runs from the west, Rockland Street, towards the back of the Aspels property. The Aspels being on the north, the Rads being on the south.
Attorney Campbell, maybe you can help me, and I don't know how well you can see. Maybe you're familiar. Actually, you can look at your copy of the record. The record appendix, volume 131. There's a bunch of color photos of the rods fence. Are you familiar?
Yes.
And I'm just trying to get oriented here. I mean, here's I don't know if you can see that. So,
yes.
Whose house is that there? What do you like?
In the background is the Rad's house.
Okay,
that photograph.
So this is the dispute area is in front of the fence.
Yes. Yes.
Maybe it's partly in front of the fence, partly in back of the fence.
Correct. Yes.
Okay.
Okay.
And some of these pictures, I mean, in this last picture, there's lots of what you call the vegetative barrier.
Yes.
Is that gone now, and that's why that's not here?
It's all gone.
Okay. Okay.
Yes.
And that went down in like around 2018.
Right. The Rads closed in 2018. Shortly after that, I forget now the exact year, they had the property surveyed because they were getting a dog, and that's when the owners discovered that the true property boundary was different from what everyone had assumed in the years prior, the decades prior, the nearly 50 years prior. There was Mr. Owens's brief talks about there being conflicting evidence with respect to the line as it's depicted in the survey, which is basically where the chain link fence is, the southern edge of that disputed property area, conflicting with the testimony of Craig Aspel and Ms. Mast, his sister, where they said that their father and Craig had mowed the grass to some feet to the south, 2 to 5 feet to the south towards the ledge or the rock that protrudes there. And there is a photograph that was taken by Mr. Rad that's in evidence, that's in the trial binder, showing the view heading from the back of the lot up towards the west, towards Rockland Street, that shows a wooden stake in the grass, which is where the surveyor staked the line that the chain link fence was installed. And it shows clearly there's several feet between the stake where the chain link fence was installed and the verdant barrier, the green screen, or whatever terms we used during the trial to describe that vegetative barrier. So there is a difference in the evidence as that was presented by the plaintiffs in the case, but there's no dispute offered by the defense. There was no evidence offered in the case disputing the Aspel's evidence that they used the entirety of the disputed area from the time they moved in 1972 until the time of trial.
Well, there's
None.
a little bit. There's the Brenneman deposition.
Brenneman does not dispute that the Aspels did what they did. He says, I wasn't paying attention to what the Aspels did. I couldn't see what was going on the other side of the trees and brush that were in between the two lots. I didn't pay any attention.
Didn't he also say that he purposefully mowed up and over because he anticipated that this might be coming down the pike?
Yes, Your Honor, which conflicts with the claim that he wasn't paying any attention to the Aspels, I would say. If he wasn't concerned with what the Aspels were doing, then why did he go out and mow there? If he was concerned about there being an adverse possession claim, that's almost an implicit acknowledgement that the Aspels were using that property, using all of that property. He did not mow, although it's really inconclusive and very difficult to determine from the evidence, from the deposition exhibits and his testimony in the deposition, exactly how often he mowed and exactly to what extent and what areas he mowed. You can't really figure that out with any degree of certainty. There's no dispute by Mr. Brenneman that the Aspels were up and down that whole area doing whatever it was that they did. He admits that they planted a tree in an area that he considered his own, but he didn't object to it. He didn't say anything about it.
He said he helped plant it, didn't he?
Joyce Aspel said that Mr. Brenneman's son, Michael, who was not a witness in the case, assisted her. He offered to help her plant the tree when she did. There had been a Rose of Sharon in the same spot. It died, and so she planted a flowering plum tree there, and when she was doing it, Michael Brenneman, one of the sons, offered to help her do it.
So it's it's I don't know how do you phrase it? It's the burden here. It's no rational basis. I mean, another way of saying it is that we have to uphold the judge's decision if there's any evidence anywhere in the record that supports it, right?
Well, there's actually a case that was authored by Justice Vuono that's cited by Mr. Owens, Brandau versus Docanto. It's an appeals court case, which talks about that. That was a land court case dealing with adverse possession. If you'd like the cite, I can get it.
It's in your brief?
It's in Mr. Owens's brief.
Okay.
I'll tell you, it's 80 Mass Appeals Court 151. It was written by Justice Vuono. That talks about that was a land court case. Obviously, no jury sat on that case. And in that case, the defendant, the appellant, argued that there was evidence in their favor. And the court discussed that issue, consistent with all of the other case law, that when there is conflicted testimony when the judge's decision is not plausibly related to any evidence in the record, when it's not plausible in light of the entire record, the reviewing court can overturn it. And that Brandau case cited Commonwealth versus Carr and the Demoulas case. And we fit squarely within those parameters here.
So actually, what I was getting at though, seems like the burden's on you to establish the factors of adverse possession, right?
Yes.
And so it's not a burden on them to
Yes.
disprove it.
Your Honor, my point is that there are not two permissible views of the evidence in this case as to a prescriptive easement. That's not close. There's no dispute on the prescriptive easement issue. It wasn't disputed at trial. No evidence was offered. The Aspels and their witnesses were not impeached. Their credibility was not called into question.
If you say there's no dispute, that's one thing. But what if the evidence just didn't arise to the level of establishing the
4 recipient witnesses testified, and
that'd be up to the judge to decide, right?
well, there were also a number. I don't know how many photographs were offered into evidence. Satellite photographs, personal photographs taken by the Aspels.
That much of the evidence centered more on the area closer to the pool and things like that, in the fence area, rather than.
That's true. But if but taking into account the fact that there was that vegetative barrier, which everyone conceded existed, taking into account that the Aspels presented evidence that through all seasons of the year, through all points during the 48 years that they'd been there, they had used that property for various reasons.
Let's assume without deciding that your case was extremely strong, that you presented that evidence. But I guess the nub of the wheel still is what the judge was entitled to do with that evidence, weighing it perhaps that there was more evidence about one area of the property than the other. Would that have been a legitimate consideration on the judge's part?
I don't think that it's a permissible view of the evidence in light of the fact that no one said the Aspels didn't do that. There was, my opponent's brief makes much of the fact that there weren't photographs taken of every single area of the disputed property from different vantage points, depicting different activities and so on and so forth. That's not a requirement of the cases. And the LaBelle versus Nelson case talks about the fact that the adverse use or the prescriptive easement use doesn't have to be consistent over time. You can have a horseshoe pit one year, you can have children's birthday parties the next year, you can have a dog kennel in another year. It doesn't have to be the same use all the time throughout the 20-year period. Differing uses over differing seasons is enough. And this area of the law, as I point out in my brief, is ancient and predates the use of photography. If adverse possession cases or prescriptive easement cases had to be vindicated through the use of photographs, we wouldn't be here today. The question is closer on the adverse possession piece of the case. I concede that. But under the Pugatch versus Stoloff case and the associated cases that we talk about in the brief, it's our position that intermittent, ambiguous mowing and nothing else over an unknown area, over an unknown period of years, is not enough to disseize the adverse possessor. The cases say that you have to bring a claim in the land court or bring an action in superior court, or you have to do a tax title taking. You have to take the property back. You have to exclude the adverse possessor. Mowing once in a while isn't enough. That's reviewed in the Pugatch versus Stoloff case. Again, a careful review of the record of Mr. Brenneman's deposition. His deposition is the only place anywhere that there's any indication that anyone else ever used that property for any reason whatsoever. And so I revert back to what I just said. Occasional intermittent acts of mowing are not enough, especially when you weigh them against 48 years of constant use. He didn't do anything else. He didn't even rake leaves. All he did was mow. And he was gone for years. 5 years going to Washington for the entire summer, going to the Cape, starting in the later years of their tenancy there, and then actually moving down to the Cape. I'd put it to you that during the prime mowing season, for many of these years, Mr. Brenneman wasn't even there. So this court is not bound by the trial court's rulings of law at all. You look at these rulings de novo, and where there's no factual evidence that undergirds the ruling, particularly as it pertains to the prescriptive easement, I would urge you to overturn the case and send it back for further proceedings.
What do you say to the issue that your brother brought up, that some of the evidence was contradictory between your surveyor and the testimony of the occupants of the home?
Yes. Mr. Owens brought that up. The survey that was an exhibit in the case and that was used by Judge Pappas in the judgment shows the southern edge of the line of the disputed property. But Andrea Mast, the daughter, and Craig Aspel, the son, both testified that Paul Aspel and Craig both mowed farther to the south by a couple of feet, and The photograph that I mentioned earlier when I was talking with Justice Massing shows it's a photograph that was taken by Mr. Rad at the bottom of the property looking towards Rockland Street. It shows where the survey stakes were before the fence was put into place, and while that green verdant barrier was still there, it shows the stake is several feet to the north of where that verdant barrier is. So the verdant barrier is the edge of the mowing, then you have the chain link fence several feet to the north of that. So that's the conflicting evidence, a dispute between my client's surveyor and my client's percipient witnesses, which is a matter of a couple of feet. It's not a question of degrees. I'm sorry, the use over the entire disputed area.
Okay. Your time is up. I'm just going to see if there's any follow-up questions. None from Justice Allen, none from Justice Massing, none from me, so thank you very much for your argument.
Thank you, Your Honor.
I have the distinct pleasure of being the first to say good afternoon, Your Honors.
Yes, you
To say it correctly, anyway.
May it please the Court. Scott Owens on behalf of the defendant appellees Teofilo Rad, Judith Rad, and their lender, Leader Bank. As the Court's already pointed out, it is my brother's client's burden to prove that they had adversely used the Rad property, and the judge found that they had not. And this was a jury-waived, finding of fact-waived trial, so we don't know what pieces of evidence Judge Pappas relied on when he reached his conclusions. But under the Brewster case that my brother referred to, if there's any combination of circumstances anywhere from whatever source that the judge could have drawn a reasonable inference in the Rad's favor, then that verdict must be upheld. And even if there is such a combination that can be found, it doesn't matter how many other combinations my brother can bring to the Court's attention that show some other possible conclusion. And we see in the verdict that Judge Pappas reached two different conclusions about two different parts of the disputed property. And I think it's relevant to consider why. What is different about the evidence that was brought to bear to the part where Judge Pappas found that adverse possession had been proved, and that part of the property where he found that no adverse use had been proved. And what's different about those two areas is the quality of the evidence that he considered. With regard to the pool area, there was ample photographic evidence in the record that showed use of the pool, that showed the pool being installed, that showed the family's use of the pool, showed other swing sets and sheds and other uses that were being made of that area. Extensive evidence that supported the testimony that the Aspel children and neighbors brought to the trial. But there were no pictures of any use during the relevant alleged adverse use period of the other portions of the property. The photos that were introduced to the areas where Judge Pappas did not find adverse use were Google photos from, I believe, 2011 onward, not something that would have supported a 20-year period of use. Those photos showed, among other things, the shed on the Brenneman property, and there were discussions about a ladder that had been placed across an opening between the vegetation and the shed. And I would suggest that such a temporary barrier like a ladder, with which Mrs. Brenneman had testified was placed there to keep children under her care from straying outside of the yard area where she was watching them, certainly allows for the inference that it was able to be moved to allow Mr. Brenneman to get beyond the shed and tend that area of the lawn that he testified that he had.
So how do you respond to the Pugatch case, which says the intermittent use without a clearly indicated purpose to take possession doesn't defeat adverse possession?
I don't think we get there because it's not my job to disprove adverse possession. It's the Aspel's job to prove it. And their evidence that they brought to bear to prove their alleged use of this area was less robust than it was to other areas of the property. They didn't have the photographic evidence. The boundary that their surveyor identified, their own surveyor identified as the area in dispute, differed from what the Aspel children testified what was the area that had been used. One might think that your own surveyor would identify the area that you're claiming properly. So I'm not sure what about their testimony changed from the time the surveyor produced the plan to the time that they came to testify. I think it's also relevant that Paul Aspel, who was the patriarch of the Aspel family and the one who allegedly started all of this adverse use, didn't testify himself. All of the evidence that was presented by the witnesses were, the woman, the now woman who was a teenage girl at the time that lived across the street, the then minor Aspel children, and what they recall of their father doing yard work. I suggest that the trial judge could certainly infer that kids don't necessarily pay attention to what they're...
Are you actually asking us to draw an adverse inference from Paul Aspel's failure to testify? Because that gets us into the motion to expand the record.
I'm not asking you to necessarily draw that inference, Your Honor. I'm suggesting that Judge Pappas could have considered it. Why am I not hearing from the individual that actually did this stuff, who may or may not have had a conversation with Mr. Brenneman about permissive use? Nobody can testify whether Mr. Aspel himself had permission to do what he allegedly did on this lawn, except Mr. Aspel. His wife doesn't necessarily know whether or not he had a conversation with Mr. Brennan. Mr. Brennan doesn't testify to having had such a conversation with him, but it's not Mr. Brenneman's obligation to disprove that. It's the Aspel's obligation to prove that their use was not permissive. And without Paul Aspel's testimony, it seems that one could reasonably infer that evidence is lacking without the additional supporting evidence that all of the photographic evidence of the use of the pool brought to kind of get over the hump in that area of the property. They're just different. And I think Judge Pappas saw that and ruled differently as to those two areas of the property. Unless there are any questions, I will rest on what I've presented in my brief.
Just to in terms of common sense and just what it seems like. There's this vegetative barrier, except for the there's a little there's an opening where the shed is, where the ladder is, but otherwise, pretty much everything on the other side of the trees and stuff is treated like the Aspel's property for almost all the time they're there, right? I mean, what refutes that? And I know you're going to say you don't have to refute it, but
I believe I cited the Calderon case. That's 360 Mass 174, and it says that the trier of fact may disbelieve even uncontradicted witness testimony. In light of the fact that there was significant evidence of use of one area and not the other, in light of the fact that the testimony that the Aspels relied on came from people who were then minors, in light of the fact that Mr. Brenneman says he used the area, he was aware that the Aspels might try to use it, and so he made a point of getting back there. One could have found, and in light of the fact that the Aspel children testified in a way that was inconsistent with the manner in which their surveyor depicted the property, I think one could reasonably say, I'm not as comfortable accepting this testimony without more, and I don't have the more. I have the more down by the pool where there's photos of years and years and years of use. I don't have the more up here, and I just don't think you quite got far enough based on that less robust testimony alone.
Could you comment on this legal point? The case law in this area, they talk about permissive use and acquiescence, and then there's, as you just mentioned, actual intent of your client to stake out his ownership. How do those all fit together? And where's the burden on who and when?
I think the burden rests entirely on the Aspels to prove each and every element of their adverse possession and prescriptive easement claim. And they have to prove beyond a preponderance of the evidence that they used a particular area. And they have to prove beyond a preponderance of an area preponderance of the evidence that use was open and notorious, and all of those things.
So, like, with respect to the plum tree, the flowering plum tree, and the mowing that the senior Brenneman did, is that acquiescence? Is that or which would not help your client, or is it permission which would help your client?
I don't know that was fully. That was fully vetted. What was discussed at the trial, and Judge Pappas took a view, and when standing on the property, one could have concluded that the very small portion of the pool fence that encroached over the line and the point at which the Aspel's vegetable garden stopped and the location of the flowering plum tree, they were all pretty consistently in line with the property line and the stakes that Mr. Rad's surveyor had placed to mark the boundary line. They were all within, a foot or so of that line. They did not, these encroachments and these uses by the Aspels did not extend all the way over to the ledge and over to where the vegetated barrier were. And I think one could draw a reasonable conclusion that if all of these things that the Aspels are doing are more or less in line with the boundary line, with the exception of the pool area where it's spilled out beyond, doesn't it make sense that they're following where the boundary line was? And what permission do they need to plant something on the line like a flowering plum tree? That's not necessarily the thing that they did to establish or as evidence of what they're alleging is their adverse use. They're talking about more beyond the plum tree and into the grassy area between the plum tree and the former vegetative barrier.
Okay. I'm not seeing any follow-up questions, and so although you have 2 minutes left, if you want to rest on your brief, that's up to you.
I will rest on my brief, Your Honor. Thank you.
Okay. Thank you both very much for your arguments. All right, the last case on our list today is a case that's impounded, Department of Children and Families versus Mother and Others, 2015-0127. Now, as a housekeeping matter, we do have a motion before the court that we had not addressed earlier, but I've just conferred with the panel, and the panel is going to permit the counsel for the children to appear. You're going to have to share time, however. Is this going to be a problem between the two of you? If you two already discussed this, it looks like everyone's doesn't have a problem. Okay, that's great. All right, so I know that you want to join in the brief, and we can officially allow that. We will. What is the time split that the two of you would like?
Can I just have one moment, Your Honor?
Sure.
Did Laura get that, how much?
What? We're going to wait. We're going to wait. Yeah, don't worry. I'm going to help her out.
All right, good.
Thank you, Your Honor, and I appreciate you addressing the motion. We're going to split 13 minutes and 2 minutes.
13 and 2. Okay, so hold on. I'm going to talk to the clerk here. 13 minutes for one, 2 for the other. You all set with that? All right. Okay. I apologize. I didn't ask for your input, but anyway, we're going to allow the motion, so we're all set. I didn't really see any problems with that. Okay, thank you. All right, so now I've called the case already. I reminded everybody that's impounded, and you can go ahead and begin your argument.
I just see that the time clock says 2 minutes for me. Is that,
It should be 13.
reversed.
Okay. It said 13 a minute ago. There we go. Now we
Oh,
have
there we
13.
are. Thank you so much.
Glad you brought that to our attention. And you can start running the clock now. Perfect. There we go.
Good
Wonderful.
afternoon, members of
Good
the
afternoon.
panel, and may it please the court. My name is Laura Smith, and I represent the appellant father. The children in this matter require the assurance of an order for contact with their father following their adoption. The court abused its discretion in failing to order post-termination and post-adoption contact between the children and their father, where the children and father requested such an order for contact. The children required the assurance of an order, and an order was in the children's best interests. The children required the assurance of an order for contact with their father because the evidence established that the foster parents had shown their reluctance and their unwillingness to foster such contact between the children and their father. Although the trial court found otherwise, the facts of this case belie that. The foster parents were able to use technology when they must comply with DCF, but not for contact between the children and their father.
Could you help me visualize this? We're talking about the family and the 3 children are in Puerto Rico?
Yes, the children and
the father is here?
in Massachusetts, yes.
Is he incarcerated at this point, or no?
At this point?
Yeah.
Understanding that's.
I'm asking outside the record, but okay.
But
But he's not planning to move to Puerto Rico or anything like that. So we're talking about virtual.
We're still talking about virtual contact, Your Honor. That's what was requested at trial by the children.
Okay, and when was the last time that the father had contact with the children?
In current since trial?
As of now on the record here. Yeah.
Oh, on the record.
Yeah.
On the record, the last time I believe was February 2023, immediately preceding the trial.
Okay.
And
wasn't there a gap before that where there was no contact?
yes, Your Honor. So when the children were removed, there was consistent in-person visitation. When the children then were placed in Puerto Rico in 2020, September 2020, there were virtual contacts between the children and their father all the way up until, I believe it was April. And the foster parents then stopped those visits because they had concerns about prior allegations between their daughter and the children's father. And those visits stopped for 7 months. And despite those contacts going well by all accounts, the foster parents unilaterally stopped them. DCF didn't file a motion, but didn't otherwise continue them. And then they did continue, but to Your Honor's point, there was another gap that was about a 2-year gap.
Yeah.
And the trial court found that that gap was not solely due to the parents. Father may have been intermittently incarcerated during that period of time. However, it wasn't.
So that 2-year gap was something that the judge could reasonably rely on to decide that an order regarding post-termination communication was not in the children's best interest, right?
Well, it's a factor. It's one factor the judge can consider, and the judge did consider. But they found that that gap in contact was not solely due to the parents' failure. DCF never filed a motion and also never provided those visits. They have an obligation, even if father was incarcerated for some of that 2-year period, they're obligated to provide at least monthly contact between children and their parents, and they failed to do so even without a motion. And the foster parents also didn't want to provide the contact, so the contact didn't occur. However, the contact did reestablish before trial. And although it was a factor in the court's determination on best interest, I'm sure, the court also found that there was a bond and that all the visits that did happen, all the virtual contacts that had happened since, were positive, all went well, and found that the children were bonded to their father. So the court found that visits and virtual contact between father and the children went well, the children enjoyed them, and that the father and children were bonded. To the contrary, the court did not make such a finding with respect to the children's relationship with their foster parents. Given their presentation, the children cannot rely on their foster parents to provide them with the option to continue their relationship with their father. Due to everything we just discussed, they're adamant at trial that they're not being order, they're able to use technology to work with DCF, but not to facilitate contact with father. The 7-month gap that happened because they didn't want to provide them and DCF failing to correct them. We also can't rely on DCF to provide post-termination visits because they've also failed in this case to do so, even without filing and getting the required court order to do so. The family dynamics here, coupled with the children's bond with their father and request to have contact with him, established the need for an order to provide the children with the assurance that they will be able to contact their father, or at least, at minimum, have the option to. An order would support the best interests of each child, despite the court's erroneous finding that it would not. The evidence at trial showed the children's positive relationship with their father, their emotional bond, and the pleasant visits that they enjoyed with him, and their own wishes to ensure that the contact continue by an order.
Go ahead.
No, sorry. So you're not contesting any of the actual findings, correct? Like, I don't see anything in your brief that any of the findings are in dispute, right? Correct?
I do believe I contest the finding that
which finding?
Continued visits were not in the children's best interests. I believe that is...
It's not a
finding of fact.
Not
per
a finding
se,
of fact. So there are no
conclusion.
facts that were found. So the facts are set. The record, so the foundation facts have been determined, and you're not contesting any of those, correct?
I believe I'm not, Your Honor.
Okay. And so essentially your argument is that even though you're not contesting that those findings supported unfitness, that those same facts do not support the finding relative to post-adoptive contact. Is that what you're saying?
Yes, I'm saying that the subsidiary findings did not support the conclusion that post-termination or post-adoption visitation wouldn't be in the children's best interest, because the subsidiary findings show the opposite. The children were bonded, the children have positive interactions with father, they go well. Father, when the visits were in person, buckled the kids in car seats, they brought food, they interacted well with them, the children listened to him, responded well to him, and there were no negative behaviors after visits when the contact then became virtual, when the children were in their current placement. DCF reported no issues with any of the virtual contacts that happened after the children went to Puerto Rico, either before that gap and then thereafter.
So at this point, the children are transitioning or have transitioned to an adoptive home, right?
Since 2020, they've been in their placement in Puerto Rico.
And my concern, and maybe it was the judge's concern, is that the father continued to be, forced into the picture might actually interfere with their ability to adapt to their present circumstances.
Well, they were placed there in September 2020. Trial was then March 2023. The children are placed with mother's parents in Puerto Rico. And the children asked for an order, at least to protect their interest in an option for contact with their father during special occasions virtually. The children had, I would say, adjusted at that point to that home, and that is where they are currently. And we'll hear from the children in a moment, I'm sure, but that would still be what I would argue is in their best interest and still requiring an order to ensure that those interests are protected. The trial court erred in finding anything but that an order for minimal virtual contact with the children and their father would further their best interests, and that the particular facts of this family warranted an order to protect and assure that these children have such contact between these children and their father will continue, or at least be offered. We ask that this court vacate the existing order and remand for an order for contact between the children and their father. If there are no further questions from the court.
Assuming that the children go on to be adopted, how do we balance the now parents' sort of inalienable right as a parent to direct their children's personal relationships?
So the order that the children requested at trial and that we would ask for here is that the offer be made to each child during those special occasions for virtual contact. So given that the family lives in Puerto Rico and father lives here in Massachusetts, there would be very minimal interruption or interference between the adoptive parents' raising of these children and their contact with their father. It would all be virtual in nature unless the adoptive parents allowed otherwise. We're asking just that an order that these minimal virtual contacts be offered to each child during these special occasions to allow the children the option whether they want to have contact with their father or not, and the impact on their adoptive parents would be slim if you're balancing those interests. If there's no further questions from the panel, Father will rest on his brief.
See no further questions. Thank you.
Thank you.
We'll hear from the children's attorney.
Good afternoon. May it please the court, Attorney Tara Morrison on behalf of the 3 children, and I appreciate the court giving me the opportunity to bring the children's voice forward here today. And I apologize for my slightly unorthodox approach, but ascertaining the children's position and having fealty to the children's position in this case has made it difficult to litigate an appeal, but nonetheless their position is important and their voice is important. Mm-hmm. I had the honor actually of representing the children also at trial, and at the time they were unable to clearly articulate a position about whether they would like to have ongoing contact with their father. I would put this to the fact that they were already had this period of separation. I think central to this case is the fact that the children were put in Puerto Rico. They're very happy there. It's a kinship placement. They're certainly in support of all the other permanency orders issued by the court. Given, as my sister counsel mentioned, the family dynamics at play here and the fact that these are children, they're receiving their information pretty much exclusively from their caregivers, their pre-adoptive parents, about their father, about the possibility of visits. Taking all of that into consideration, my position here today on their behalf is that at the very least, they should have the option for some kind of virtual contact with their father if they should want that in the future. And as it stands with the orders as they are today, there's no preservation, there's no guarantee that that will occur. And I don't see any harm to my client's position either in remanding to the trial court where there could be a reevaluation of whether the adoptive placement has provided those visits, how has it been going, and see the children are older now and implement some sort of a visitation plan that would allow them to state whether they want to see their father or not, make the choice, and then get an understanding of who their father is from contact with him as they get older. Is there any reason why
you couldn't, if we affirm this order, is there any reason why you couldn't do that anyway? Go back to court?
If this order is affirmed, the father has no more rights at all to visitation.
Right, you're representing children.
I'm sorry.
You're representing the children.
Yes.
Could the children go into court and say, hey, we'd like to, we've asked mom and dad to be able to Zoom with dad on Christmas, and they said no, but we want to.
a very interesting question, Your Honor. I don't believe, my understanding is that the children would not have standing, at least in the juvenile court, to seek such an order, and I don't know that they'd have standing in probate court either, based on the termination of the parents.
I don't know either.
Right.
You know.
So my understanding is that once this order goes into place, it's solely the prerogative. I would also be dismissed as counsel for the children. That would be another complicating factor. But the sole prerogative would be the adoptive parents deciding, they'll have full legal custody. It is up to them whether or not the children have any contact with their father.
We've actually given you some extra time.
Oh, I apologize.
That's okay. We gave. I have my eye on the clock, and it is extra time. But your sister did not take all of her time, so I seem to be fair. But at this point, however, we are going past the entire 15-minute time. But if you'd like a sentence or two to sum up, that would be fine.
Thank you so much, Your Honor. I would just ask that the court consider the fact that the children, have changed their mind several times, and that, if that continues to happen, it would be better to have their rights so preserved with an order for visitation.
Well,
thank you.
We appreciate you coming here to express their point of view. Thank you.
Good afternoon, Your Honors. Robert Fairburn. May it please the Court, Robert Fairburn on behalf of the Department of Children and Families. Your Honor, the trial court properly concluded that post-adoption contact between an incarcerated father with a decade-long history of domestic violence and who did not contest his unfitness at trial would not be in the children's best interests. In leaving the nature, manner, and duration of any post-adoption contact to the sound discretion of the kinship pre-adoptive placement, the trial court properly applied the two-pronged test found in the adoption of Alona, which balances the needs of the children and the presumption that adoptive parents will act in their children's best interests. Your Honor, the first element of the Alona test is to determine if visits would be in the children's best interest. Here, the trial court did not find that. The trial court found that it was not in the children's best interest. And indeed, Your Honor, I think if in the 159 findings of fact, the court details the nature and history of why this would not be in the children's best interest, including father's intermittent incarceration, multiple acts of domestic violence in front of the children, and the fact that he at times would disappear and have no contact with the children after 2019. And also failed to engage in any service plan tasks that would allow him to ameliorate the parenting deficits that he was not contesting. Even if although the court did find a bond, Your Honor, Adoption of Douglas makes it clear that the bond that requires a visitation order is something more than just simple visits that went well. And veto itself requires that it needs a significant existing bond, the disruption of which would be detrimental to the children before a visitation order goes in place. In fact, in Alona, the court even found a significant bond between mother and child, which the court did not find here, and the court still declined to enter a post-adoption visitation order and left it at the sound discretion of the pre-adoptive family.
But didn't the court find a bond?
The court found a bond, Your Honor, but the court did not find a significant bond. And even in cases where the court finds a significant bond, like Alona, Your Honor, the court is not required to enter an order for a post-termination and post-adoption visitation.
Can you answer the question that was raised earlier about whether or not the children would have the opportunity or the standing to go into the juvenile court to request visitation?
My apologies. Oh. It's the department's position that under Section 26, all parties have a right to review and determination prior to adoption. So as long as the adoption is not finalized, the children are a party to the case and could bring an action under Section 26 asking for a visitation order.
But that would no longer be a possibility
after adoption. There is no other option available. But before adoption, there is an option, Your Honor.
All right. Well,
And the
thank
parents
you.
are still pre-adoptive at this point?
They are still pre-adoptive. We can the court cannot finalize the adoption, Your Honor, until the appeal is settled.
That makes sense.
Yeah.
And if there are no further questions to the panel, the department would rest on its brief.
Matt, questions? I see no questions from the panel. I want to thank everybody very much for coming here today. As I always say in these cases, we know they're difficult. We know everyone does their best to represent their clients, and we'll look at the case very, very carefully. Thank you. Court will stand in recess.